Today. Let's see, probably switch back and forth. Although it's a little colder outside, so.
It is.
Oh, I'm good, thank you.
Do you like one?
Mint.
Peppermint?
All rise for the jury. All rise. Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
Have a seat. We're on the record. This is case number 21CV001001, Timothy J. Murphy versus City of Painesville, continuation of the jury trial. The jurors are in the courtroom. Morning, ladies and gentlemen. And plaintiff, call your next witness.
Thank you, Your Honor. We'd like to call our expert, Dr. Justin Wyrick, and his testimony will be by video.
All right, ladies and gentlemen, this is one of the videos that I mentioned during jury selection and also in my opening instructions. You are to take this witness's testimony as if he were in court. This happens often with doctors. You may continue.
I'm Rick, representing the Bureau of Workers' Compensation.
Thank you. And Dr. Will you please raise your right hand? Do you solemnly affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
Great. Good morning, Doctor. My name is Corey Kuzma. I represent Timothy Murphy in this matter. I appreciate you taking the time to take your deposition today. Can you please state your name and spell it for the record?
Justin Wyrick, Justin Wyrick.
Okay, and doctor, just to get this out of the way, what is your professional address?
39000 Menor Avenue, Willoughby, Ohio, 44094.
And that is where we're taking the deposition today, correct? Okay. And what is your profession in general?
I'm a chiropractic physician.
Okay. And I have a copy of your resume if you need it. You might have one in front of you as well. I just wanted you to take the time and explain to the jury and give them some background about your educational background and job experiences leading up to today's deposition.
I've been a chiropractor for about 18 years now. Originally started in Columbus, moved up to the Cleveland area, spent some time in Warrensville, and then over the past 11 years, I've owned this business with my business partner. I am an athletic-based patient supporter. I enjoy working with athletes. I enjoy working with complicated cases. I enjoy my profession as much today as I did when I was a student, and not much more to say.
Okay, great. And can you describe to the jury just your educational background in terms of where you went to school and any licenses that you have?
Correct. My undergraduate was at Windberg University. It's in Springfield, Ohio. Postgraduate was National University of Health Sciences in Lombard, Illinois. That's where I received bachelor's in science and my doctorate in chiropractic. I spent some other time prior to at Kent State and Ohio State, but my licensure for being a chiropractic physician was through National University of Health Sciences.
Okay, and when was that? When did you get your license to be a chiropractor?
2004.
2004, and you've been practicing consistently since then?
I have.
Okay. And are you licensed to practice in the state of Ohio?
I am.
Okay. Any other states?
Just Ohio.
Okay. And any additional licenses or experiences that you have after becoming a chiropractor?
I have certifications in kinesiotaping. I took applied kinesiology when I was a student. It's a diplomate course. I did not pursue the diplomate, but I did complete 100 hours of applied kinesiology when I was still out in Chicago.
And we're here today not to get into the details yet, but obviously we're here to discuss my client, Mr. Timothy Murphy, and issues he's been having with his hands and wrists in regards to potential carpal tunnel syndrome. Are you familiar with carpal tunnel in general, doctor?
I am.
Are you experienced in actually diagnosing and or treating it?
I am.
In both?
Yes.
Okay. And doctor, can we agree today to state any of your opinions or conclusions to a reasonable degree of chiropractic certainty?
Yes.
Okay, and will you use all of your education, your work experience, and any experiences you had specifically with Mr. Murphy in order to honestly answer any questions that I or Attorney Nimberg will ask you today about Mr. Murphy?
Yes.
Okay. Doctor, you described your common practice about being a chiropractor here. What exactly do you do, just to give the jury some idea, on a day-to-day basis with patients and clients?
My patient base is wildly varied. Personally, I'm a rehabilitative-centric individual. I like to work with injured workers, injured patients, injured athletes from start to finish. I am hands-on in developing the rehab protocols. In the event that something is outside of my scope that I cannot handle from a conservative basis, I tend to refer those individuals for outside diagnostics, evaluation, consultation, just to try to get everything to the end range for the individual. If they came in with an issue, we try to get a resolution of the issue.
Okay, and what are some typical issues or injuries or complaints that a typical client, I know all of them are different, but that you deal with on a general basis?
Widely variable. I manage spinal conditions, disc herniations, stenosis, degenerative disc disease, neural encroachment, pinched nerves, shoulder issues, rotator cuff tear, labral tears, tennis elbow, meniscal tears, arthritic joints throughout the body. I have several patients that ultimately come to need orthopedic intervention. I like working with those individuals because they typically have more complicated issues, and I like a challenge.
And do you personally render treatment to any patients?
I do.
And consult with them?
I do.
When you render treatment, what typical kind of treatment do you render? Physical therapy and...
It depends on the individual. So, depends on the case, depends on the presentation. I will typically see the patient first and foremost, and I'll develop a plan of care based upon what I find. There are times when I will immediately send them out for further testing, further imaging, before I do any therapy. There are cases where we'll start conservative therapy, see what the response to care is before we decide to refer out. There are times when I treat them from start to finish. They never have to be in my office, so we can do all of our therapy here within the office to come to a resolution of their issue.
When you refer a client out, or say you mentioned an orthopedic consultation,
Sure.
Can they come back to you and you discuss the findings and maybe a course of treatment following that?
Absolutely.
It just depends on the client.
Correct.
Doctor, what is an occupational disease?
Occupational disease is something that occurs over a long period of time. It's not a singular mechanism of injury. Somebody slips and falls in the parking lot, that is a singular mechanism of injury. You can tie it back to what happened, what body part was injured. An occupational injury, an occupational disease is something that happens over time. It's not a singular event.
Okay. Can you give us some examples of what an occupational disease would be?
Case in point, carpal tunnel. Carpal tunnel is an occupational disease. It's been widely recognized as an occupational disease due to several factors depending on the work environment. Occupational disease, you tend to see that individuals such as carpenters or drywallers, they tend to have more cervical and shoulder issues because they spend more time doing activities in an overhead plane. Most of the general public doesn't tend to do those activities in an overhead plane.
So sticking with carpal tunnel, what are the ways that someone could develop or get carpal tunnel in general?
Repetitive stress activities, vibratory exposure, any activity that puts consistent compression over top of the carpal tunnel.
And this might be sort of a simple or silly question, but can someone develop carpal tunnel syndrome either through maybe at home activities that they have, maybe at work activities that they have, or is it maybe a combination of the two? What in your opinion, is someone who develops carpal tunnel, what are some typical ways that they can get it?
To answer your question, yes, it can happen at home, it can happen at work. You have to identify what activities they're doing. Repetitive stress, if they're sitting there and performing the same fine motor skills with their digits, sustained wrist flexion, anything that's going to be repetitive on a consistent basis.
And what are the ways that you personally would diagnose carpal tunnel syndrome in someone?
Take a comprehensive history, evaluation consisting of orthopedic tests, evaluation of the region, motor strength testing, range of motion evaluation, sensory evaluation.
Okay. And you take all of those in consideration when making your diagnosis or deciding not to?
I do.
And you talked about diagnostic testing. Well, what would that be in relation to carpal tunnel syndrome?
Typical diagnostic testing is through EMG or NCV, electromyogram or nerve conduction velocity.
Okay. And I'm familiar with the EMG. Was there a different test in there that you mentioned, or is that the same thing?
Nerve conduction, so basically they're looking at functionality of the muscle, functionality of the nerve.
Okay. And as an EMG, would you consider that maybe the golden standard of whether or not someone has carpal tunnel syndrome?
I would.
In conjunction with any other factors that you've mentioned?
It is a diagnostic test which is as objective or could be more objective than clinical testing.
Okay. And what clinical testing would there be? What would be examples of clinical testing that you would perform on someone?
In the case, I can refer to Mr. Murphy. I performed 3 orthopedic tests, I believe, valence test, reverse valence test, and Tinel's test.
And what type of tests are those, just for the jury? And I'm not too familiar with them either, but what are those, how do those go about being conducted, and what kind of results are you looking for?
So for valence tests, you're looking at putting the wrist in the position of maximal flexion. And a positive finding is an indication of pain, numbness, tingling, paresthesia, if that develops to the course of holding that anywhere from 30 to 60 seconds. Reverse valence is basically going in the, valence and reverse valence. So valence would be flexion, reverse valence would be extension. Same response. You're looking for sensory abnormalities, increase of pain. That's the diagnostic test for those two. Tunnel's tap is where you basically take a reflex hammer right over top of the carpal tunnel, tap over top. If you have an increase of perceived pain by the individual that follows the nerve distribution, that'll be considered a positive Tunnel sign.
And I know you kind of mentioned or answered this before, but maybe in more detail. To someone who's not super familiar with carpal tunnel syndrome or occupational diseases, what is the gist of what carpal tunnel syndrome really is when it comes down to it?
Carpal tunnel syndrome is compression or irritation of the median nerve as it passes underneath the transverse carpal ligament. Transverse carpal ligament runs right across through here. When you develop carpal tunnel, you develop increased pain. It can be achy, throbbing, burning, sharp, variable by the individual. Another hallmark with carpal tunnel is abnormal sensation, numbness, tingling, pins and needle sensation. Another condition with carpal tunnel is you tend to see muscular atrophy in the thenar musculature at the base of the thumb right across the neck. That tends to happen in individuals that have had it for a longer amount of time than you see the atrophy.
So the repetitive activity or the other issues that would cause carpal tunnel, is that because it causes inflammation or it directly involves the nerve moving? What would you characterize carpal tunnel being in that sense?
And typically what happens is you get an inflammatory response which creates more pressure as the nerve passes underneath the carpal tunnel. And that inflammation occurs with repetitive activities, sustained activities, overt stressors applied to that region that aren't normally encountered through the course of the day.
So you already mentioned repetitive activities could cause carpal tunnel or at least lead to symptoms developing it. Would direct trauma or physical work also do the same thing, or is that different?
It could.
Okay. And in what ways could that cause carpal tunnel?
If you had a steel beam fall right over top of your wrist, increased compression at that point, that's direct trauma. That could create carpal tunnel. Similarly, a vibratory effect where somebody is using a motorized piece of equipment over time creates inflammation, especially if the individual's wrists are in a position of flexion where we are again creating more compression over top of the carpal tunnel.
And in general, doctor, does someone who does repetitive work for a living at their job, are they at a greater risk of contracting carpal tunnel or another occupational disease rather than someone who doesn't?
In my opinion, yes.
And doctor, this is a general question too, but does everyone who is exposed to repetitive activity at work automatically contract carpal tunnel or an occupational disease?
Not in mine.
Okay. What are the reasons or factors that you have to consider in terms of whether or not someone would actually develop carpal tunnel based on their work activity?
If you're looking at work activity as the nature of activity, duration of activity, is it done, on a standard 40-hour week basis? Does it exceed the 40-hour week basis? Other factors that can contribute towards it is not so with duration, but like tenure. Is it done over a month's period of time, several months period of time, year after year after year? To me, if you're doing something consistently over a longer period of time, the rate of developing carpal tunnel increases.
Okay, so generally the length of time someone's doing maybe repetitive actions or physical work would be a factor to consider whether or not carpal tunnel could develop. That's fair?
That's fair.
Okay. And doctor, I wanted to ask you, there's risk factors associated with carpal tunnel that are taken into consideration whether or not someone is likely to develop it. Is that true?
That's true.
Okay. And do you know what those are offhand? I had to look them up myself, but do you know what those are?
So there are risk factors that include some autoimmune issues such as rheumatoid arthritis. Those individuals who are considered obese are considered a higher risk factor for carpal tunnel. Hypothyroidism, because it is a metabolic disorder, those individuals with hypothyroidism and thyroiditis tend to have a higher propensity to developing CTS. Women tend to have a higher propensity to developing carpal tunnel than men. Diabetes, type 2 diabetes tends to be a predisposition for developing carpal tunnel. You may have heard of diabetic neuropathy. That's one of the reasons why carpal tunnel is sometimes seen in a higher percentage of diabetic patients.
I don't know if you mentioned it. What about smoking? Is smoking a risk factor of developing carpal tunnel?
It would, yes.
Okay, and this was one that I had to look up myself, but hormonal replacement therapy, is that a factor, a risk factor as well?
I could see that being a risk factor.
Doctor, we talked about the different ways to diagnose carpal tunnel syndrome. You brought up the EMG, you brought up the clinical examination testing. Is there anything else that you would like the jury to know that you take in consideration whether or not someone is developing or has carpal tunnel syndrome in addition to doing those tests and the EMG?
The history is very important.
Okay, and Doctor, let's get into Mr. Murphy. Do you remember in general when you first started treating or seeing or consulting with Mr. Murphy about any kind of medical conditions?
From the very beginning?
Yes. First time you saw him?
First time I saw Mr. Murphy, he came in and he presented with a bilateral knee injury.
Okay. Do you remember what year that was?
2014 or very early 15.
And what kind of treatment were you giving him, either personally or any kind of consultation you were giving him in regards to his knees?
I evaluated him, we developed a care plan. I could not start treating him therapeutically during the initial phases because as part of that injury, he had developed a deep vein thrombosis and a pulmonary emboli, and I needed to wait until I spoke with and received clearance from his other providers before he could engage in any type of therapy.
At any point treating him for those knee issues, did you ever treat him specifically for his knees or wrists before 2015?
No.
Do you know of any injuries that Mr. Murphy had prior to 2015 directly to his knees, to his wrists or his hands?
Not to my knowledge.
Any other body parts that you know Mr. Murphy has issues with?
His neck.
Do you know why?
I believe it was incurred through the course of his work duties.
And during your treatment with Mr. Murphy, or Mr. Murphy's treatment with you regarding his knees, would he complain about any other body parts to you besides the knees or the neck that you had to take in consideration or consult him on?
There were issues which are included in my report. He had complained of issues, dropping objects, razors, silverware, glasses, cell phone perhaps. Another issue that came up which eventually led to his referral to the neurologist was facial tingling, facial paresthesia, which was a concern. He also was having issues with shortness of breath, which was occurring around the same time that happened as well.
Do you remember around what time that was, what year?
This would have been, he was still off work, so I believe it was 2015. It was about midway through 2015.
Okay. And is your understanding that he was off of work, I'll just tell you for his knee issues, from about November 2014 until June 2015, does that seem accurate?
It does.
So you just testified that Mr. Murphy was complaining about a number of symptoms, but some dealing with his hands and wrists in give or take about 2015. Is that correct?
Correct.
Okay. And you recommended that he go get a referral and go see a specialist. Is that right? All right. Doctor, I'm going to hand you what has been marked as Plaintiff's Exhibit 2. Can you just take a look at that real quick and let the jury know what it is?
This is Dr. Weinberger's initial consultation note from June 3rd, 2015, and then his subsequent EMG report that was performed on June sometime in 2015.
Okay. And doctor, looking at that EMG, can you please read what the impressions are on that?
Nerve conduction study and needle examination of bilateral upper extremities and cervical paraspinals were performed. See details in table. Results were abnormal because of the following. 1. Bilaterally prolonged median sensory latencies consistent with a mild bilateral carpal tunnel syndrome. 2. Otherwise negative study with no electrical evidence of cervical radiculopathy. 3, the patient was advised to consider a consultation with a hand specialist to treat the carpal tunnel.
So in general, for the jury's sake, what does that EMG show?
Mr. Murphy had electrodiagnostic evidence of mild carpal tunnel syndrome in both of his wrists.
And did that EMG confirm or deny any radiating neck issues Mr. Murphy had at that time?
It ruled out that the sensory abnormalities were coming from his neck.
Okay, and looking at it real quick too, just to confirm, on the EMG, can you read who the referring doctor was? It's at the top right.
That would be myself.
Okay. So this EMG, it looks like it's from July 2nd, 2015. Is that fair?
I believe that. He didn't have on the date, but let me see his report. Yes, July 2nd, 2015.
Okay, and attached to the EMG is a note from Dr. Weisberger from June 3rd, 2015. Is that correct? Or Weinberger, I apologize.
Correct. This would be his initial consultation.
Okay, and in the history of present illness, it states, I'll just read it. He has subsequently been seeing Dr. Weirick for chiropractic treatment, who recommended neurological consultation. Is that your understanding?
That's correct.
So at this point, this note is from June 3rd, 2015, so it only stands to reason that you talked with Mr. Murphy about his ongoing hand issues and neck issues prior to June 3rd, 2015.
Correct.
All right, let's get back to Mr. Murphy's work history. We narrowed it down that he was off of work for an unrelated knee issue from November 14th until about June 2015. Prior to him being off of work, can you describe to the jury what type of work Mr. Murphy actually did?
His recitation towards me, it was a highly physical job. He was operating machines, he was operating different vehicles, manually lifting, throwing bags of filled leaves into collection bins, using jackhammers, using weed whackers, breaking up asphalt, raking asphalt, tamping hot asphalt, cold patch, using chainsaws. It was, by his description, a very physical job.
And do you know offhand, or reading your records, or reviewing for your deposition today, how much of Mr. Murphy's duties actually involved power tools or vibrating tools?
If I can go back and look at when I saw him being part-time. I mean, to add on to before, I recall the weed whacker, I recall the sledgehammer, I recall the jackhammer. Those three stand out as the vibratory tools that he used. Looking back at my report from May 18, 2016, he talked about using a crack seal and tar distributor one with ball valves. My notes indicate these instruments require twisting the wrist back and forth throughout the day to promote the flow of material throughout the lawn. It's not an actual mechanical device, but it's still something that is fine motor controlled. Yeah, I've got jackhammers and weed whackers, vibrating tampers and rollers, hand blowers to remove debris from potholes before adding fresh material, chainsaws, hand trimmers, overhead chain pruners, and hand pickers to remove trash from the designated mowing areas. Steel hand tamps throughout the calendar year to tamp out creases in new asphalt and to tamp cold patch into potholes during the winter months.
And that's your understanding that's a pretty accurate description of Mr. Murphy's duties from the city of Painesville?
I would, yes.
Do you know how long he worked for the city of Painesville?
31 years.
Okay. Do you know if those duties ever changed, or if that's pretty consistent to what they were for the longevity of his career?
I can only assume that would be his duties for the longevity of his career.
Okay. All right. And so that was prior to him being off from his unrelated knee issue in 2014. So let's get back to when he went back to work for the city in about June 2015. Is that correct?
Correct.
Okay. And what's your understanding of his job duties at that time?
He was on modified duties when he returned to work. He returned to work and he was put in a position where he was mowing at a cemetery, I believe. Evergreen and Riverside cemeteries. He was working 8-hour shifts 4 days a week. The entirety of his shifts during that time frame, over 2 to 3 weeks, was he was operating a zero-turn radius tractor, and he was mowing for the entirety of his shifts.
And what's your understanding of what issues he was having following that modified duty?
During that time frame is when he developed a more consistent presentation of the carpal tunnel syndrome.
Okay. What symptoms specifically do you remember?
Throbbing pain, achy pain, motor weakness, grip strength weakness.
And you say more consistent. So what's your understanding of what his carpal tunnel-like symptoms, we'll just word it for that, like that for now, what they were prior to his modified duty?
As I said before, taking a history is important. He said that he has had comparable symptoms in the past while performing his work duties, but they resolved without any type of intervention. During this particular time frame, they did not go away with independent measures.
Do you know offhand how long it would take for his past issues to resolve? Would it be a couple of hours, a couple of days? Would it depend on activity?
I couldn't say offhand. He just said that they were able to resolve on their own or go away on their own without requiring any intervention.
And as far as you know, he didn't have any ongoing treatment or any specific treatment for carpal tunnel prior to any modified duty with the city?
Correct, not to my recollection.
And do you know how long he was on that modified duty for?
2 to 3 weeks.
Okay. And doctor, what is the date of your report that you're reading from?
May 18th, 2016.
Okay, so let's get a timeline together. So you just testified, you spoke with Mr. Murphy about some ongoing issues that were resolving prior to his modified duty with the city. Is that correct? He returns to modified duty, he's on that for 2 to 3 weeks, and then at some point you and him rediscuss having issues with his wrists and his hands. And in between that, he goes to see he has a neurological consultation, EMG, confirming carpal tunnel syndrome, correct?
Correct.
So what happens between him having modified duty, having the EMG in 2015, and then your report in 2016? Do you have a timeline about what happened, progressed, where you wrote the report?
I know at that point when I sent him over to Dr. Weisberger, he had returned back to work. Based upon my records, he had switched from doing mowing duties after that, and he was working with the city. He was working as a flagger. He was concerned because he still had the carpal tunnel symptoms while he was working as a flagger. He had difficulty, doing what he needed to do to operate the flow of traffic. I recall that from being in my notes. Mr. Murphy ultimately retired from his position with the city of Haynesville at the end of that year.
So Mr. Murphy works with modified duty. He retires in December. I think the official date is either December 31st, 2015 or January 1st, 2016. Is that accurate?
Correct.
And so he retires. You write a report in May of 2016. Is it your understanding, did any of his symptoms resolve from when Mr. Murphy retired in December or January until you wrote your report in May of 2016?
It was 6 years ago that we did this, but Mr. Murphy presented to me because he was still having the carpal tunnel symptoms.
And in your report, you specifically note at that time you did the clinical examination tests on Mr. Murphy. Is that right? Okay. And can you read for the jury? I believe it's on the second page what those tests were and what the results were.
I separated the right wrist versus the left wrist. Do you want the whole physical examination for both wrists, or do you just want the tests?
Here, I'll give you my copy. I highlighted at the bottom where the tests were, so I think that might be the most useful. It's at the bottom.
So for the right hand and wrist examination, reverse valence test reproduced pain and a cramping sensation into the first and second digits after 15 seconds. Tennell's test reproduced pain in a medium nerve distribution. Finkelstein's test reproduced complaints of pain over the dorsal radial aspect of the wrist. Motor strength of the right wrist was grade 4 flexion, grade 4 plus flexion, grade 4 extension, and grade 5 radial ulnar deviation.
So at that time, you examined Mr. Murphy for carpal tunnel syndrome, and based on your clinical examinations, he has it. Is that fair? And that was a few months after his EMG that confirmed it in July 2015.
Correct.
Well, let me ask you, is it significant, or what does it mean where Mr. Murphy retired and you examined him a few months later and he still had signs of a positive carpal tunnel examination?
I hate to use those old saying of a straw that broke the camel's back, but he offered a history where he had comparable symptoms to carpal tunnel in the past that resolved without intervention. When he came to me, he identified that modified duty that he had embarked on in June as being what set everything into effect, and it didn't resolve at that point. So again, it was 6 years ago. Based upon my review of the records, he came in with those symptoms that remained consistent even beyond and into his retirement.
And are you familiar with Mr. Murphy's either hobbies or outside of work activities?
The man likes to hike, the man likes to walk. He finds it beneficial for his knee injuries. He finds it a way of getting up and being moving. I actually looked at his chart from when he initially presented in here, and I found this interesting. You know, he'd stated, I would like my hands to quit aching and be able to recover the strength of my wrist. I would like to write and draw without pain and numbness, so I can infer that one of his hobbies would also be drawing. But just with casual conversation with him, I know the man likes to be outdoors and he likes to walk and I know he likes to hike.
Okay. Are you aware of any outside hobbies or anything that Mr. Murphy could have been doing after his retirement that could contribute or be the cause of his carpal tunnel?
Not to my knowledge.
Okay. And kind of going back, when Mr. Murphy was off of work, obviously for the unrelated knee issue, is there anything that you are aware of, either talking to Mr. Murphy in your notes or reports or anything, in regards to any aggravation or ongoing or further issues with his carpal tunnel during the time that he was off for his knee issue?
I think my initial, I cited some records that prior to him going over to see Dr. Weinberger, he was having some exertional dyspnea, and it was more facial numbness that was going on. And after he had returned into modified duty, I recall the flagging issue. There were other notes that I reviewed where he had talked about dropping glasses. He had talked about dropping his silverware, but I believe that was after he had returned back to modified.
So is it fair to say from what you know that when Mr. Murphy was off from November until June of 2015, his carpal tunnel symptoms pretty much stayed consistent, similar?
Correct.
They didn't get better, they didn't get worse?
Yes.
Okay. All right. And Doctor, one last exhibit. I'm going to hand you what's been labeled Plaintiff's Exhibit 1. Can you look at that and tell the jury if you're familiar with that record?
This happened in July 18th of 2019, and it appears to be a consultation with Dr. Weisberger, who is an orthopedic doctor.
Okay, and that is different than Dr. Weinberger, who Mr. Murphy saw in June 2015.
Who is a neurologist, correct.
Okay, and I'll tell you there's 3 different treatment notes there. I'm really going to only ask you about the first one, but July 18th, 2019, October 31st, 2019, and a February 13th, 2020.
Okay.
That seem accurate?
That is.
Okay. Looking at that first one, it looks like that's the first time Mr. Murphy saw Dr. Weisberger. Can you just summarize for the jury what the reason why Mr. Murphy was there for a consultation?
Mr. Murphy is a 6-year-old male who comes in today for evaluation of right-sided hand pain. He notes he has had some issues with carpal tunnel on and off in his hand for several years, about 4 to 5 years. He notes he is already taking multiple other medications for a previous lower extremity injury, but they do not seem to be helping his hand. He has been using a wrist brace, which helps the carpal tunnel symptoms, but does not seem to help his thumb. Denies any other treatment for the hand or fingers, and no locking or triggering of any digits. He notes the hands do frequently fall asleep on and off during the day. Day wakings from sleep that night. I'm just reading verbatim.
Yes.
And he has difficulty feeling and holding on to small objects. Dr. Weisberger did observe a positive Tinel and Durkin's test at the wrist.
So in summary, Mr. Murphy sought out a consultation for carpal tunnel-like symptoms in 2019.
Yes.
Okay. And at that point, it looks like it's still the clinical examinations, the similar or same ones that you did in 2016, were still positive for carpal tunnel.
Yes, Tinel's were still there. He performed Durkin's. I did Phelan's and reverse Phelan's.
And are you aware, looking at that record, of any treatment that was rendered to Mr. Murphy that day?
He was injected at the right thumb carpal joint, and he had recommended a thumb spica splint from the 7/18/19 data service with Dr. Weisberger.
Okay, and I'll ask you, would an injection in the thumb help with any kind of carpal tunnel symptoms? Okay. So you sought out Dr. Weisberger, who had positive clinical findings for examination of carpal tunnel syndrome. He had an injection which was not related to carpal tunnel syndrome. But can you read the very bottom? I know it gets cut off, but it picks up on the second last page, just up until the end of the first sentence on the second page.
I discussed with him, because he has had long-standing issues from the carpal tunnel, I feel that it is a large driver of his symptoms, and surgery for carpal tunnel release would likely be beneficial.
Thank you. So it's fair to say, based on those records, based on your records from 2016, that it seemed from 2016 up at least until 2019, Mr. Murphy still had the carpal tunnel-like symptoms.
Correct.
Okay. Okay. Can you go back to your report one last time? I just wanted to point out, it's on page 2, presenting symptoms. I think you read it the first time, so I'll just read. The patient stated that he continued to drop objects with his right hand, and he noted that he has been switching hands when he feels the presence of fatigue or paresthesia. Is that correct?
Correct.
So what is that a symptom, or is that a typical problem that someone would have if they were to have carpal tunnel, the fatigue specifically?
Yes.
So what causes that?
Carpal tunnel is suppression of the median nerve. The median nerve controls both sensory interpretation and motor function of the hand. So median nerve, if you get weakness, common finding in individuals with carpal tunnel syndrome is they have grip strength weakness. It involves primarily first, second, third, and half of the fourth digit. So an individual holding on to an object for any amount of time fatigues out quicker than a person that does not have carpal tunnel syndrome.
Doctor, generally, is it unusual for someone to be diagnosed with bilateral carpal tunnel when they're right hand dominant?
I wouldn't say it's unusual. You tend to see a presentation of carpal tunnel affects the extremities being used. If it was a slot machine operator who only ever used his right hand, I would assume that individual would be more prone to developing carpal tunnel with that right hand. But if there is an active engagement with both upper extremities at the same time, then the risk is going to be the same from side to side. I do recall that when reviewing my notes, Mr. Murphy quantified his right side as being more provocative than his left side. That is his dominant side.
So to sum it up, it pretty much is based on what type of activities or maybe direct trauma or injury someone would have to either one of his or her hands or both.
Correct.
Okay. Doctor, what is your understanding of, scratch that. Doctor, you testified before, strike that actually. Doctor, you testified before about your understanding of the type of tools Mr. Murphy used at the city of Painesville for over 31 years, correct? You talked about lawnmowers, chainsaws, tampers, weed whackers, jackhammers. Are there any other tools that you can think about, Pam, that we didn't talk about?
Maybe the ones I said with the overhead chain pruners and hand pickers and hand trimmers.
And I'm just going to ask you, are you generally, I'm not asking if you use those personally, or at least all of them, but are you generally familiar with all those types of equipment?
I am familiar with that equipment, and I do use most of those.
Okay. And in your opinion, are those the type of tools that could lead to someone developing carpal tunnel syndrome?
Sustained exposure, repetitive exposure, yes.
Okay. In your understanding of Mr. Murphy's work duties and his length of using those types of equipment during his tenure with the city, is it your opinion that that type of equipment could cause carpal tunnel syndrome?
Yes.
Okay. Anything else about the manual and physical aspect of Mr. Murphy's job that we didn't go over that you used in your opinion?
I tried, once again, I keep referring back to the history. I can't comment because I don't know if he was working greater than 40 hours a week or not greater than 40 hours a week. That would be a question to pose to him. I think it illustrates an above average or an above normal rate of abnormal stressors that were applied to his upper extremities, specifically his hands, based upon the work activities that he told me that he was responsible for performing.
Okay, and two follow-up questions to that, because I was going to ask you, in your opinion, do you think what Mr. Murphy was doing with the city of Painesville exposed him more likely than not to carpal tunnel as opposed to some other job?
I do.
And generally, in your opinion, was Mr. Murphy at a greater risk of developing carpal tunnel than the general public?
I believe so, yes.
Okay. And Doctor, I'm just going to ask you, because obviously you wrote reports on this matter, and you wrote a rebuttal report to Dr. Trangle, is that correct?
Correct.
I'm not going to go over all of his arguments. He has his own deposition. Obviously, this is yours, but I wanted to ask you your thoughts on what I am calling and quoting the rotational duty argument that Dr. Trangle uses in his report that you read, where Mr. Murphy was less likely to be exposed to developing carpal tunnel syndrome because his duties were so varied throughout his activities at the city. The question is that type of defense credible? Is that something you agree with? What are your thoughts on that type of argument that because Mr. Murphy did so many different types of jobs, even involving power tools, vibrating tools, physical activity, that he's less likely to develop carpal tunnel syndrome because he has so many different duties?
I responded to Dr. Trangle's IME. He performed one in April 11th, and I felt that his proposal of a planned rotation, I found that highly subjective. There is no way that I think that Dr. Trangle would find out exactly how long Mr. Murphy was doing a set test. There are seasonal tests, but how can he sit there and determine or differentiate how many hours over a given week that he was operating a chainsaw, a hand pruner? How many square feet of asphalt did he need to break? Just because there are several different jobs that are being outlined in his job duties, there's no way for Dr. Trangle to definitively state this was planned. I'm only going to run a chainsaw for X amount of minutes or so many certain days. I'm only going to cold patch for X. He has no way to say that within a reasonable degree of certainty. It's a subjective impression, and I found myself highly disagreeing with that statement from him.
Okay, and would it be fair to say that the time spent on those tools and that machinery and the type of activity really rests in what Mr. Murphy's actual duties were and how he describes them with the city of Painesville?
I have many patients that have worked for different cities. These individuals do the job until the job is done. It's not, we'll do it for 3 days and then we'll switch to something else. They do it until the job is done. Whether it's 3 days, 3 weeks, 3 months, they do it until the job is done.
And Mr. Murphy never conveyed to you that he had any type of limitations or any type of revolving orders from anyone at the city in terms of how he did his job?
Had he conveyed that, it would have been in my notes.
Okay. All right. Doctor, getting to your opinion specifically, with respect to Mr. Murphy's work activities, did you arrive at a diagnosis regarding Mr. Murphy based on your examination, review of the records, and any testing that was done?
I did.
And what is that diagnosis?
Carpal tunnel syndrome bilateral.
Okay. With respect to that condition, what facts and findings led you to that diagnosis? I know we talked about a lot of them today, but just to summarize for the jury.
Comprehensive history, medical history of the individual, obviously my clinical findings, and then the electrodiagnostic testing.
Any reason to believe or any doubt in your mind that Mr. Murphy even has carpal tunnel syndrome?
Can you repeat that one more time?
Sure. Any reason to believe that Mr. Murphy may not have carpal tunnel or doesn't have carpal tunnel syndrome?
My opinions as of May 18th, 2016, definitively it was within my reasonable degree of chiropractic certainty that he had carpal tunnel syndrome.
Okay. And doctor, is your diagnosis opinion you hold that in respect to Mr. Murphy solely based on your education, training, professional experience as a licensed chiropractor, and the record?
Yes.
And doctor, do you have an opinion regarding the cause of Mr. Murphy's bilateral carpal tunnel syndrome that you diagnosed?
I could recite my report, but in paraphrase, yes, I think it was directly and causally related to the work activities of the city of Batesville.
Okay. Are there any, I kind of asked before, any outside activities or hobbies or other injuries that you think could have been contributed to Mr. Murphy's carpal tunnel syndrome, in your opinion?
Not to my knowledge.
Okay. Any other medical, strike that. And doctor, again, we went over all the typical carpal tunnel risk factors. None of those Mr. Murphy has ever been diagnosed with.
Correct.
Okay. And doctor, generally, do you believe to a reasonable degree of chiropractic certainty that bilateral carpal tunnel was caused by Mr. Murphy's work activities?
I do.
And simply put, more likely than not, Mr. Murphy's work activities with the city of Painesville causes bilateral carpal tunnel over anything else?
I believe so, yes.
Okay. Thank you, doctor. Those are the questions I have for you right now.
Thank you.
Thank you, Doctor. My name is Sandy Nemrick, and I represent the Bureau of Workers' Compensation in this action. I have a few questions for you to follow up. You testified that you're a chiropractic physician. Is that right? You're not a medical doctor.
I'm not.
Okay. And as a chiropractor, you cannot prescribe medications. Is that right? You're not allowed to perform surgery.
I'm not.
You're not board certified in any medical specialty.
I'm not.
And you cannot do injections on patients, for
I cannot.
example. You cannot admit patients to hospitals.
I cannot.
You testified that you first treated Timothy Murphy following his injury in November 2014 when a steel plate had fallen on his legs.
Correct.
I think you said it was early 2015.
And 14, early 15, I'm not sure the exact date.
I think, do you have your notes with you?
Not for the 2014.
If I told you that you first saw him on, I believe it was January 6th of 2015, would you have any reason to dispute that?
I can validate very quickly.
Okay, that would be great.
January 6, 2015.
Okay, now when you first saw him, he didn't have any complaints related to his wrists at all at that time.
Not to my knowledge.
He was complaining about his legs and about issues arising from the pulmonary embolisms he had developed as a result of that injury.
To my recollection.
Okay, and I believe you testified that you have not seen nor are you aware of any medical records from before that time regarding any wrist symptoms that Mr. Murphy has.
Correct.
Okay, could you testified that at some point in the spring of 2015 he mentioned he was having pain and numbness down his arms into his hands. Could you tell me when that was that he first complained to you about his wrists?
believe I'm just going to defer to, I also did a response to Dr. Sadaka's initial physician review for claim allowance. So this would have been one of my reports that I wrote on February 10th, 2017. 4/16/15, he complained of shortness of breath while he was on the treadmill. 4/23, again, shortness of breath, dyspnea. Patient did not complain of lightheadedness. No change in swelling, redness, temperature in his lower extremities. 4/28, the dyspnea hadn't changed, more fatigue and more lightheaded. Patient completed exercises. He was advised to consult with his pulmonologist. 5/5/15, at some point he had been admitted to TriPoint. They couldn't find anything to explain the shortness of breath. Developed left facial numbness, been coming and going. Dr. Blair, who was a clinical pulmonologist, did pulmonary function test yesterday, said I had issues. Patient reported shortness of breath with initial stages of exercises, but then an improvement with duration of activity. 5/7/15, breathing sounds later today. A few more episodes of the left facial numbness. Patient is going to seek neuroconsult with Dr. Weinberger. These are all just paraphrased from my progress notes.
Okay, and I'm looking at those actual notes from those dates, and that looks like an accurate recitation of what you'd written in those notes. So there's no mention there about numbness into his wrists, is that right?
Correct, that was primarily for facial numbness.
So he was having facial numbness and shortness of breath that gave rise to concerns about potential neurological issues. Is that right?
Not necessarily neurological, but the gentleman had a DVT and a pulmonary emboli with the shortness of breath. I wanted to make sure, and when he developed the facial numbness on top of it, that was where the neurological referral came into contact.
Okay. So you referred him at that time to Dr. Weinberger, who is a neurologist.
I did.
Right. And you also were aware that Mr. Murphy had a history of cervical or neck problems. Isn't that right?
I am.
Okay. And if you would look back at Dr. Weinberger's report, which I believe was marked as Plaintiff's Exhibit 2. That Dr. Weinberger saw Mr. Murphy on June 3rd of 2015, is that right?
Correct.
And at that time, Mr. Murphy had not yet returned to work, had he? I think if you look at your June 3rd note, I think you have a note from that day indicating he was going back the next day.
Okay, I'll defer to my notes, so that theoretically could be correct.
Okay. And in fact, if you look at the bottom of Mr. Weinberger's note, he indicated the bottom of the first page of his report.
Okay.
He indicated he has not worked since his leg injury and pulmonary embolism last year, right? Okay. And looking at the first paragraph under history of present illness, he indicated this is a 56-year-old man with neck pain and numbness for several weeks. The patient has been experiencing neck pain off and on for several years. And then a little further down, it said he has numbness going down the arms into the hands bilaterally from time to time. And it says he's been seeing Dr. Wyrick for chiropractic for treatment, who recommended a neurological consultation. Is that right?
Correct.
So this is the first mention we've seen in the records about this numbness going down into his hands. Is that right?
Correct.
And on page 3, at the bottom, under provider impressions, Dr. Weinberger indicated he does have cervical disease and some of his symptoms may well be attributable to cervical radiculitis, and he recommended an EMG study of the upper extremities looking for radiculitis or neuropathy. Is that right? So that's how he came to have that EMG that was done a month later on July 2nd.
Correct.
And I assume that delay of that month is a scheduling issue that's pretty typical for medical testing. Is that
It
right?
is quite probable.
Okay. Now, Mr. Murphy returned to work shortly after he saw Dr. Weinberger with restrictions, you indicated, correct? And he was assigned to driving a riding lawnmower for a couple of weeks, is that right? You continued to see him regularly during that month after he returned to work, isn't that right?
Correct.
I think you were seeing him a couple times a week?
Correct.
Okay. And is there anywhere in your notes where he indicated that he was having problems with his wrists or that the mowing was bothering his wrists?
Full disclosure, I did not review the entirety of my notes, particularly with that claim, so I couldn't state whether there was or there wasn't.
Okay. So if I told you that during those visits during the month of June, he was complaining about his knees and that the work was bothering his knees, but there was no mention of his wrist, do you have any reason to dispute that?
I wouldn't.
Okay. All right, and you, Mr. Kuzma, went over the July 2nd, 2015 EMG report from Dr. Weinberger. That he lists you as the referring physician on that, is that correct?
Correct.
And it indicated in the impression findings consistent with mild bilateral carpal tunnel syndrome. Is that right?
Correct.
There was a recommendation that Mr. Murphy follow up with a hand specialist.
Correct.
To your knowledge, did he ever follow up with a hand specialist?
Dr. Weisberger would be my knowledge that I found out today.
And he saw Dr. Weisberger in, I believe it was July of 2019. Is that correct?
July 2019, correct.
Okay. And that was plaintiff's exhibit 1. That was about 4 years later. Is that right?
Correct.
So you're not aware that he saw anybody in the interim?
Not to my knowledge.
Okay. And at the time he saw Dr. Weisberger in July of 2019, he referred to the fact that he had had a recent fall a couple months ago. Is that right?
That's right.
And then he was having these problems with his thumb and with carpal tunnel symptoms.
Correct.
And in fact, Dr. Weisberger did an injection in the thumb at that
Correct.
time. And I believe you testified on direct exam that that injection in the thumb wouldn't have anything to do with carpal tunnel syndrome.
It would
It's
not.
a different thing.
Correct.
All right, you, after he had the EMG done, you continued to treat him for his leg injuries from the 2014 injury throughout the rest of 2015 while he was still working.
Correct.
Was there any mention in any of your treatment records during that time about his wrists?
Again, without me looking at the notes, I couldn't definitively say, but I will tell you, since he was under my direct care for the knees, I would assume that most of my focus at that point would be with his knees, especially with him returning back to work.
But if he'd been telling you that his work was bothering his wrists, I assume you would have written that in your notes, wouldn't
The
you?
burden itself, if it's even something outside, that's why I was able to draw some of the other issues that I comment on in my reports.
Now, there was some talk about Mr. Murphy's job duties. I want to show you. I'm going to have marked as Defendant's Exhibit A. Have you seen this before?
I believe I have, because I think this played into the factors of him going back to work, and I need to look at his work duties before I released him back unmodified.
Okay, and this is in fact the official job description from the city of Paintsville for his job, is that right?
Yes.
Okay. And according to this, he did a wide variety of things, including operating various types of trucks and equipment and tools and and all maintenance and repairs and road repairs and all kinds of things, some of which we talked about, is that right?
Correct.
Now, after Mr. Murphy retired, you were still treating him regularly, again, for his knees, is that right? Between the time he retired at the end of 2015 and the time you saw him on May 18th of 2016, when you wrote your report for this case, do you have any notes showing that he was complaining about his wrist during that time?
I do not.
And are you aware of any other treatment he had with anybody else related to his wrist?
I do not.
And if you would refer to your May 18th, 2016 report. I don't think we've marked this one yet, so this will be marked as Exhibit B. And just to verify for the jury, is this in fact a copy of your May 18th, 2016 report?
It is.
So you indicated as to the onset and mechanism of injury, Mr. Murphy presented to this office with complaints of pain and paresthesia of the bilateral hands/wrists and a median nerve distribution that has been consistently present since June 15. Is that correct?
That's correct.
Now, when you indicate that these symptoms have been consistently present since June of 15, you're relying on Mr. Murphy telling you that.
It's part of the history, correct.
Right, because there's nothing in your records to indicate that.
Correct.
You said he offered a work history that included several repetitive stressors and physically demanding duties. However, the onset of his symptoms occurred through a consecutive day time frame in June 15 while he was operating a riding mower. Is that correct?
Correct.
He was responsible for mowing the grounds of the cemetery. And you said he worked in this capacity for 2 to 3 weeks with progressively worsening symptoms in his bilateral hands and wrists, pain and paresthesias. And again, you're relying on that history that Mr. Murphy gave you because there's nothing to that effect in the records, is that right? And in fact, he had seen Dr. Weinberger before that return to work, is that correct?
For the consultation, correct.
He noted that the symptoms worsened to the extent that he felt medical intervention was necessary, and he underwent electrodiagnostic testing with Dr. Weinberger on 7/2/15. Is that what you wrote?
Correct.
Okay. Well, in fact, I think we've established, haven't we, that he didn't seek treatment with Dr. Weinberger after he started this mowing. He had already seen him and
For
already
the
had the
consultation,
EMG.
correct.
And already had the EMG.
The EMG should have been done during the time frame that he was mowing. Because of that coincides with him returning to work in June of 2015. The EMG wasn't done until, so that should have been during the time frame that he was doing that modified activity.
Right. My point is he didn't start the mowing, have these issues, seek the treatment, and seek the EMG.
Correct.
That was already planned to be
Correct.
done. Right. Okay. And Mr. Murphy stated that he has not sought further care for his bilateral wrist hand complaints and is concerned about the presence of non-resolving pain and paresthesia in the absence of aggravating activities. So again, he was indicating that even though he'd been retired now for 4.5 months, his symptoms weren't getting any better.
Correct.
Okay, and again, if you look at page 2, near the top, and first full paragraph, he said, Mr. Murphy stated that he did not experience a consistent presentation of bilateral hand pain and paresthesias until June 15. Is that right?
Correct.
And again, you are relating this to operating the mower.
Correct.
And then under presenting symptoms, you indicated the patient described the pain as predominantly achy in character, but noted that he experiences episodes of throbbing pain in the hands bilaterally when performing sustained activities, i.e. writing, housework, yard work, etc. Is that right?
Correct.
So those were things he was doing at home in the normal course of life, housework, yard work, writing. Okay. And those were aggravating his symptoms. Thank you, Doctor. I'd also like to show you what's going to be marked as, I guess, Defendant's Exhibit C. Have you seen this document before, Doctor?
I have. It's a first report of injury.
Okay. And is this the first report of injury that Mr. Murphy signed on May 18, 2016?
It is.
And that's the document that he filed with the Bureau that gave rise to this claim for bilateral carpal tunnel syndrome.
Correct.
Is that right? Okay. And in his description of injury here, he indicated, I returned to work in June of 2015 after a big steel plate.
860 pounds.
Oh, okay. Oh, after an 860-pound steel plate fell on me, I was put on mower, zero turn, and I started having numbness to my hands and started dropping objects.
Because of all the vibration, I went to the doctors with severe numbness in my hands. I have run vibrating tools for 31 plus years at the city.
Thank you.
Yes.
I have my breathing glasses on. Okay. And Doctor, when's the last time that you treated Mr. Murphy specifically for his wrist?
The 5/18 of 2016.
So you haven't seen him since then regarding his wrist?
I have not.
Have you continued to treat him for his knee problems?
I have.
And I believe you treated him at least during 2019 regarding his cervical problems?
We did start that claim in 2019, correct.
Are you still treating him for his neck?
I am.
Okay. How often do you see him?
Once a week for his neck, and he's getting ready to be withdrawn from his knees after one more visit.
Okay. And are you aware of anyone else he has seen other than Dr. Weisberger back in 2019 regarding his wrist?
I believe it's just Dr. Weisberger.
Okay. And he's never had any surgery on the wrist, has he?
Not to my knowledge.
You're aware he has an underlying platelet disorder that precludes him from having surgical procedures? All right, I don't have anything further.
Doctor, just a few follow-up questions. Attorney Nimrick asked you about some questions regarding that there's no further treatment for Mr. Murphy following your report until he sees Dr. Weisberger in 2019, correct?
Correct.
Just so we're on the same page, his claim, that's what we're here for now, has not been recognized or allowed for carpal tunnel syndrome, correct?
Correct.
And so he cannot get treatment under his claim for that condition.
Correct.
Okay. And she also asked you some questions about treatment notes from you before your report in 2016, May of 2016. Is it your understanding that when you see a patient for a specific claim, you try to, or what's your understanding of limiting it to those specific body parts as opposed to other body parts that aren't recognized in the claim?
If I can speak freely, I've been a BWC certified physician for most of my practicing career. You tend to try to focus the direction of your medical documentation on the above regions of the claim. Because as soon as you start talking consistently about other regions, then the reviewers come back and we are critiqued for treating non-allowed conditions. So, of course, I've talked about, there were issues with that was pertinent in the notes, but you can't go ad nauseum. It's not a global comprehensive medical treatments for the allowed conditions of the claim.
Okay. And Doctor, just so the jury understands your position, because you read some from your report, the first report of injury, you're not saying Mr. Murphy got carpal tunnel syndrome from his modified duty in June of 2015. You're saying it's from a history of him working from the city of Painesville, in addition to anything that might have happened when he did return up until his retirement.
Correct, which is an occupational disease.
Okay. And Doctor, anything that Attorney Nimrick asked you, did it change your opinion in any way, or anything you want to comment on about your testimony on direct examination before, or does your opinion still hold true that you believe more likely than not Mr. Murphy's bilateral carpal tunnel syndrome is a direct cause, is directly caused from his work with the city of Painesville?
I maintain my opinion.
Okay. Doctor, those are all the questions I have for you.
Thank you.
All right, ladies and gentlemen, I'm going to give you a short break before we look at the next video. While on the break, remember the admonitions I've been giving you all along, and you did notice that there was some dead air space on there. That's intentional. I instructed the videographer to delete some irrelevant content, and you'll probably see the same thing on the next video too. All right, go ahead and take a break. Be about 10-15 minutes. That record should reflect that the jury are out of the room. Plaintiff offering what exhibits, 1 through 7?
Technically, Your Honor, it is 1 through 6. I tabbed them out. 7 was left open just in case there's any rebuttal exhibits used during any kind of, during Mr. Murphy's testimony.
All right, so you're offering 1 through 6. Any objection?
No objection.
They are joint exhibits, Your Honor.
They are joint.
And I would just proffer in, I know I already filed one with the court, but just another hard copy of Dr. Wyrick's testimony, just for the record. Not as an exhibit, just for the record.
Yeah. The woman from Nepal would never understand. I had a hard time because they spoke very quickly, and they used some terms of art, so you had to really listen intently to understand.
And Dr. Finger's probably a bit harder because he does speak very quickly.
Okay. Yeah, it's times like this that I wish these videos had closed captioning. Just a suggestion.
They actually can.
Okay.
I have had to have one. I've had to have one before. My expert was very, very elderly. He was a medical doctor who just liked to testify in his old age, and it was very difficult to understand. And I think it costs extra to caption it.
Well, the closed captioning is necessary if I had a deaf juror on here. Their lips are moving so quickly. I mean, if I can't make out 100% of what they're saying, when they're speaking so quickly and using, like the EMG and NC, nerve NCS, NCT.
Nerve conduction velocity.
Yeah.
That's a good point. Usually for me, I have the exact opposite problem where they're talking so slow. But that's That's a good idea.
That's usually south of the Mason-Dixon line. They've got that slow drawl.
But that is something to keep in mind. Yeah, because I was Dr. Wyrick too. We talked to him just normally. He's very easygoing, and then when he started testifying, it was a lot quicker than I was anticipating.
My wife and I have closed captioning on all TV.
Yeah.
The kids hate it. I said if I wanted to read a book, I wouldn't be watching a movie.
They'll appreciate it eventually.
Yeah. Plaintiff rest?
Yes, following the exhibits. Yes, Your Honor.
And defendant's motion?
Yes. Yes, at this time, Your Honor, the defense would make a motion for a directed verdict based on the fact that the plaintiff has failed to meet their burden of proving that Mr. Murphy contracted bilateral carpal tunnel syndrome in the course of his employment with the city of Kingston.
And I have to take Dr. Wyrick's testimony at face value in ruling on the motion, and he says it, and therefore there's enough to go to the jury. So overruled.
Thank you, Your Honor.
All right, and then when they come back, we'll play Kevin Trangle's video, and then I'll go right into instructions. And just for the record, Matthew Ivanich got here at 8:52. That was, well, I looked at the time. Was that the individual at the door?
Yes.
Okay. And let's put on the record then what we talked about this morning. Yesterday, we noticed juror number 8, Matthew Ivanich, struggling to keep alert, at times just downright sleeping. I had my bailiff at the break tell the juror to drink caffeinated coffee. He could bring the coffee into the courtroom. He didn't bring the coffee into the courtroom, but I think he had his eyes open the remainder of Mr. Murphy's testimony. This morning, he calls before 8:30 and says he's running late. Be here 8:50, and I had counsel come into chambers. Everybody saw that he was struggling to stay awake. We determined to make him, select him as the alternate since we haven't picked an alternate. And since he wasn't here and we were ready to proceed and we needed to proceed, we agreed that I would discharge him, and we would go with the 8 jurors. We expect to finish this today. We expect to get it to the jury by their lunch, and because we do have a hard stop today at 4 o'clock, that would still provide them more than enough time to deliberate based upon the many workers' compensation jury trials that I've had, Mr. Nemrick's had, Mr. Kuzma's had. And we also agreed that in the unlikely event we lost one more juror, we would proceed with 7, with 6 having to concur on a verdict. Is that correct?
Yes,
Mr. Quinn?
Yes, sir.
Okay. Anything further on the record, that topic or any other topic?
Not at this time, Your Honor.
No, Your Honor.
Okay. Take a few minutes break.
All right.
You want to walk around for a few minutes? Probably 5 minutes. Did it? the thing, it's probably one of the biggest gripes we have is one of the reasons, and I tell clients this all the time, but the jury doesn't get the this is so separate. I'm going to touch the line and I'm telling them that I'm going to tell them, I would rather have a treating physician, someone who's familiar with my client, who's familiar with your treating you, BWC, who's certified, who's able to testify. Doctors won't testify. Treating doctors are too big to testify. New age doctors do not want to waste their time testifying. I had one surgeon testify to a person who was expert in that. The only time they have medical doctors testify, and this is pretty on that line, out there, explain, is when they're paid by EDA to do a review, to spend just 2 hours on your claim overall, render to the team, to get paid for anything. So that's, on the end of that, it depends on the and I'm going to bring up privately, technically true in the claim, which is after how many years of issues are unresolved, and I'm not just bringing it here, but you got to do that. So that explains the gap. That explains the gap. Yes. Yeah. Right. So that's where I'm going to kind of negate that argument that you just waited because it wasn't, and whatever. I mean, you had other issues. I'm going to explain why there was a gap. But you tell the jury too. Dr. White explained the report. We're in trial. It is October 2022. Dr. Strangle. He's been going.
I remember when you saw it all dark hair. Yeah. I seemed like, uh-oh.
That's all. Screwed up. This one did get postponed, but not really because of COVID. But, yeah, those I sort of got, I think. But it's like, I think everything's good.
Yeah, and I'll book a trial, do, like the full trial support.
Yeah.
And it'll get postponed, and people still think they're on top of the list, so I said, well, you postpone later, I already have someone else just like you.
Yeah.
And I've got 5 to 6 people that will be
Yeah.
a month. So I keep trying to.
And I think
Yeah, it's like.
they got their idea.
And of course, the attorneys and full reporters.
environmental medicine is the individual that has an injury or that has medical illness or disease. It's figuring out how to best rehabilitate them, how to treat them, how to deal with them. It's really more of a treatment aspect of it.
Do you have admitted privileges at any area hospitals?
I do. I'm on staff in university hospitals, so I have main campus in Ahuja over here in Detroit. I'm also on staff at the Cleveland Clinic, main campus, and primarily Hillcrest is where I practice.
And have you done any teaching?
I've been on the teaching staff at the university since I've been in Cleveland, which is, I guess now, it's almost 35 years.
Are you currently engaged in the private practice of medicine?
I am.
And for how long?
Probably can define that since I've been in Cleveland, which is now 35 years.
Have you had occasion to testify in workers' compensation cases before?
I have.
And have you testified for claimants or defendants or both?
I've done both. At this moment, I'm probably 55-60% more plaintiff testimonies I've done on not only how and other states. It used to be a little more for the defense, but now it's probably what I just said.
And in the course of your practice, have you treated patients with bilateral carpal tunnel syndrome?
Frequently.
And is that something that regularly falls within your areas of specialty?
It is. It's also something that we have designed. We're going to get into this. I've designed ergonomic programs. I've been very involved in ergonomics with companies. I've been involved with consultant ergonomic testing company where we really do physical demand analysis, looking at the jobs and trying to redesign the jobs to make sure we prevent injuries such as carpal tunnel. And I've been hired by organizations to put together ergonomic job analysis and ergonomic job modifications to prevent carpal tunnel syndrome, such as I was hired by AGA Gas at one point in time when they were having a rash of carpal tunnel syndromes because they had to screw off and on all the gas taps. So we devised we looked at the problem, we devised a mechanistic device that prevented that in the future. So yeah, I know carpal tunnel pretty well.
Could you define for the jury what carpal tunnel syndrome is?
I can. Make it interesting, I can show you a picture. Should we do that?
Sure, let's go off the record for a moment.
I didn't think about this ahead of time. You just asked me. Is this a good angle for you? Okay. I actually have a slide here somewhere. How's this for being topical?
Back on the record.
All right, so the question is, what is carpal tunnel syndrome? So this is a hand. This is the nerve that comes out here that goes through the wrist. I guess it's this wrist right here. If you look, so there's something called the carpal ligament. If you see here, it's a ligament that goes right on the wrist here. And through that, we have both nerves that come through this particular area. And right here is a median nerve. This is the one right up on top. It goes underneath the carpal ligament and innervates these areas of the hand, these fingers. So carpal tunnel simply is when this nerve gets compressed. So it can get compressed because there's a whole variety of reasons it can get compressed. But if it gets compressed because you have tissue swelling or you have a variety of medical problems and diseases, or sometimes, about half the time, we never actually figure out a cause, then you develop symptoms. What are the symptoms? You basically have numbness that goes into these particular three fingers, sometimes the fourth fingers. It's very characteristic, but that's what carpal tunnel syndrome is.
And what causes carpal tunnel syndrome?
Half of the time, we never find out what causes carpal tunnel syndrome. It just happens. It happens as we get older. It just happens, and we don't find the reason. There are diseases that are associated with it, such as diabetes, some medications, hypothyroidism, autoimmune disease, cardiac congestive heart failure, people that retain fluid for whatever reasons. There's a variety of some hematological issues that can cause it.
So there are things that are associated with it. You can also get it if you have highly repetitive job activities. If you are on an assembly line and you're moving things 1,000 times a day, week after week, month after month, yes, that can lead to carpal tunnel syndrome too.
Okay, and could you define what you mean by highly repetitive work activities?
It's people that actually do the same activities. We're having flexion. You sort of see it here when you have flexion, extension, or repetitive movements like this all the time when you're doing something different. The same thing over and over again. We occasionally see people that are on the keyboard for day after day if they don't have ergonomic keyboards, such as our sonographer here. That will happen. We see it in sort of different processions. Typically, if you're like a jackhammering 8 hours a day, month after month, I may see that in people like that. I actually work with companies to design preventive programs so people don't have carpal tunnel. Everybody works full time. But if you can have job rotation and you can ergonomically design the workplace, then you don't have an issue.
How is carpal tunnel syndrome diagnosed?
There's, I would say, 3 main ways of diagnosing it. Number one, it's the symptoms. You have to have a consistent story of symptoms. And the symptoms are that basically you have radiating pain and numbness, but there's many things that cause that. It's typically into these particular fingers, and I just showed you where the median nerve comes, which is the thumb, first, second here. It's really typical. It also happens at nighttime more than the day. So when you lay down at night, you redistribute the fluid in your body, and the fluid, which has now been in the lower half, it redistributes to the hands. That's why people that have carpal tunnel will actually have nighttime problems with waking and having numbness and pain just at nighttime. Same thing happens in pregnancy when you retain fluid. So you have to have a very consistent history that's very relatively specific for carpal tunnel. The second thing, you have to have findings that are consistent with carpal tunnel. Findings are, you can have a decreased sensation, and we measure that using, I don't have one with me, but we have little pinwheels where we can measure 3, 4, 5, 15 millimeters. We see basically how sensitive the fingers are. And once again, you look at these 3 fingers, which is pretty characteristic. You see these 3 fingers have a much different sensitivity than these 2, for example, one hand versus the other. That's consistent with carpal tunnel. You also should have demonstrable weakness, reproducible, consistent. That can be also consistent with that. When you stretch the nerve, as you see in the diagram, there's Valen or reverse Valen. By stretching the nerve, if it's sensitive and it's either inflamed or has some degree of ongoing pathology, then you can reproduce some of the symptoms by doing that. Tinels is when you tap it. These are things you've probably seen or will have heard in the trial. That will characteristically lead to a radiation of pain to the 3 fingers we talked about. Those are the clinical findings. So you want to have clinical findings. The last thing is having an EMG study. An EMG study is it's kind of an art form. It depends who's doing the EMG study, how accurate it is, and it depends where you have it done and who the doctor is. And it can be completely obvious that somebody has carpal tunnel or nerve derivation, or if they have some mild slowing, in which case it's not necessarily diagnostic. When I approve these for insurance purposes, which I do, working with insurance companies and as medical director, we'd like to have all 3 of these present to really validate that somebody has carpal tunnel syndrome.
Did you have an opportunity to examine Timothy Murphy on April 11th, 2022 at my request on behalf of the Bureau of Workers' Comp?
I did.
And did you also have an opportunity to review medical records regarding Timothy Murphy?
I did. I reviewed records at that time. Since then I got more records, issued an addendum. Since then I have more records. Today I use the Eugene by Plaintiff Counsel, more records.
And what records did you review?
Well, the list in my first report, there's about 11 records. They come from the chiropractor, from Lake Hospital. There's Dr. Weinberger, the new one is Dr. Lucci, I think. There was an EMG study, there's Dr. Sagako's report, Dr. Weilick's report. I also received from via the plaintiff counsel a 10-page recitation of all the jobs he did while he was at the city working as a maintenance worker. And then I had additional records I received later and issued an addendum on July 19th from different claims. He had a couple of the claims, and I wanted to make sure I had some of those records, at least 4 of the claims I knew about, so I got those records additionally.
Okay. And do you have the records in front of you?
I do.
Did you also prepare a report of your examination and findings with regard to Mr. Murphy?
I did.
And you also mentioned that you prepared an addendum report?
I did.
And do you have those in front of you?
I do.
Were you able to obtain a history from Mr. Murphy and from the records you reviewed?
I did. I mean, he gave me a really complete history, and then he asked me if he could write down everything he did. And I said, absolutely. So I saw him on April 11th. Apparently, just before that, maybe in preparation of this, he prepared a 10-page document going through all the variety of things he did as a city worker. I mean, I was impressed. He had a recollection going back 30 years of all the things he did. He must have been keeping a diary because it's pretty complete.
And generally speaking, what is a history?
A history is when you ask somebody, we're doing this in an occupational context, so we want to find out from a medical perspective, what is their medical issues. So we ask about hospitalizations, medical diagnosis, allergies, medication. We ask about operations they've had, procedures, injections, all things medically oriented. When we're talking about a work-related potential condition, and we get in a lot more into also the job description, what they did at work, what they do at home for fun. Sometimes people fly fish 8 hours a day or whatever they happen to be doing. We do a much more expansive history and trying to figure out all the things they do. And we look at all the records that are available. That's medical history.
And what was the relevant history you obtained from Mr. Murphy and from the records you reviewed?
Well, a lot of it, let's start with his job, number one, before we get into the actual medical part. So we went over his job, we went over what he did, which I summarized in my first report, and then I got in addition to that his 10-page, really detailed explanation of what he did. So what's relevant is the fact that he did a lot. He had a great deal of variety in what he did in the last 30 years. And it's comported with what he told me, that he never did anything very long. He went from this to that, sometimes leaves, planting, lifting, carrying, cable jackhammering, sometimes riding a mower, driving vehicles. He did a variety of different things. In fact, to answer your question, what impressed me is when I design job rotations at companies for wind carpal tunnel, I mean, this is like a dream description. There's so much variety in what he does. He's not doing anything highly repetitive for any length of time at one point. So this is the kind of thing I would actually devise, and it probably would not have as much variety as he was able to demonstrate in his response to me and what he told me. So that was, I think, very important. In addition to that, in terms of the history, is we went over how he told me it came on. And at one point he said, I've had it gradually increasing for 30 years, but not enough he told anybody. I mean, he didn't really tell anybody for years and years and years. And then at another point he said, well, it was when I came back after a knee problem I was having. I was riding the mower, and that one day or a couple days, suddenly I had a significant problem. I developed carpal tunnel. That was relevant in terms of the medical history that I got from him. And then I went on to his other medical problems. He has a variety of medical problems. He has had surgery and medications and hospitalizations in the past. which were important to understand in the context of what he has ongoing.
And were you also able to examine Mr. Murphy on April 11th of this year?
I did.
Could you describe your examination and your findings?
Sure. So the examination is basically, we did the height, weight, blood pressure, the staff fills that, to come in and do that. And then I examined him, and the focus was really on his wrist and the carpal tunnel issue in this right-handed man. So basically, examination of his wrists showed him that he has really pretty normal range of motion. We test what we call a flexion towards the palm, dorsal extension. We check ulnar and radial deviation. Those are the 4 things we do. So they were pretty good. We also checked for any evidence of swelling or inflammation. There was none. We can do that just by measuring his wrists and just looking for tenderness, redness, and swelling, which he had none. He had good pulses, checked his reflexes, which were brisk and normal. On top of that, I checked for the 2-point discrimination. What that means is you get like 2, we have actually a device to do this. We have like 2 needles. We'll see how far apart you can tell. So people with normal sensation can tell, 4, 6, millimeters. People that have problems, I sometimes go 15 or 20 millimeters, which is both sides of the thumb, where they can see the difference. His was completely normal on all of his fingers and both hands. So sensation was good. He had no lack of sensation. He had no lack of range of motion. We tested the tenelles and the phalanx, which is one of the signs, the classic signs of carpal tunnel on both sides. He did not have any positive signs. In fact, the only thing that he had that was, quote, abnormal was that when he was tested for grip strength, you're supposed to squeeze as hard as you can. We have a special device for that. And you should be within 10% if you're trying hard. His went from 2 to 8. I mean, he had variations of 4 times, so which means he really wasn't trying hard when he was doing that. That was the only abnormality, but that was really voluntarily because he was not really trying his hardest on both sides. Otherwise, he had a normal exam.
Did you also review the report of the diagnostic test known as an EMG that was done on Mr. Murphy on July 2nd of 2015?
I do. I have it here right now.
And what is the significance of this report for the issues in this case?
Well, they did it, Dr. Weinberger did this at the request of his chiropractor, Dr. Werner. And what he found was he wanted, number 1, check his cervical spine and see if there was a nerve being compressed to the cervical spine, which clearly there was not. And then he wanted to check if there was any either motor or sensory abnormalities at the wrist. What that means in English is you have a couple of nerves that go through here. One is motor nerve, and the other is a sensory nerve, and you can test both separately. So his motor was really pretty normal, and he had slight delay on the sensory. This could be consistent, but in this case, I would not even think really diagnostic of mild carpal tunnel syndrome. You have to correlate clinically when you have these mild abnormalities. So Dr. Weinberger said yes, there were some mild sensory abnormalities, which could be consistent with mild bilateral carpal tunnel syndrome.
Okay, and are EMGs used to diagnose both wrist conditions as well as cervical conditions?
They're helpful, but in a case like this, they're not the end-all be-all. They're not it's not like you take an x-ray and you see a cancer. You have to take this in context with the exam. You have to look at the actual EMG and see what it's showing and how significant it is and how delayed it is. You have to look at the other things such as fibrillation, testiculation, which we can talk about, velocity. So you look at everything together and you get a sense that there may be something that's amiss, but you have to correlate that clinically and with your physical findings.
And Doctor, I'm going to show you what's going to be marked as Defendant's Exhibit A.
Thank you.
You could take a look at that for a moment and then let the jury know what this record is.
This is a June 3rd, 2015 University Hospital clinic note that Dr. Weinberger wrote.
And Dr. Weinberger is the same doctor who performed the EMG about a month later, is that right?
Correct, in July of that year, that's correct.
And this record was dated June 3rd of 2015, is that right?
It's correct, yes.
And if you look at the beginning of it, would you let the jury know what it is that Mr. Murphy saw Dr. Weinberger for at that point?
He saw him for his neck pain and numbness, which he had had for several weeks. That was his chief complaint. He had been experiencing that actually for years, not for just weeks. And Dr. Kellis referred him to Dr. Weinberger to evaluate for this. He had a number of other complaints. He had just got out of the hospital at Tri-Point, and he had things such as a pulmonary embolism, he had hypertension, he had van Willebrand's disease. He had a number of medical issues, but the chief reason for seeing him was his neck pain and numbness radiating into his hands from his neck.
Okay. And if you look at the very bottom of that first page, was Mr. Murphy working for the city of Painesville at the time of this visit?
No, he had not worked for almost a year at that time.
And that was a result of another injury, is that your understanding?
It was a result of, I think primarily he had a pulmonary embolism, which sidelined him, but he also had some other musculoskeletal issues.
And if I could refer you to page 3, which is the last page of this record.
Of course.
In the bottom paragraph, what does Dr. Weinberger recommend?
He has cervical disease. He believes that it may be cervical radiculitis. He has carotid potential stenosis. So he wanted to do an EMG study to try to sort out what he had. He wasn't sure. The chief diagnosis was neck pain with radiating numbness.
Thank you. And I'm going to show you what's being marked as Defendant's Exhibit B. You had discussed Mr. Murphy's job duties with the city of Painesville.
Correct.
Could you tell the jury what this record is?
This is the Painesville-generated position description of a maintenance worker 2, which is where he fell in terms of the categories of jobs.
And is this consistent with the 10-page document that Mr. Murphy sent to you regarding the variety of jobs that he did?
It's consistent. I mean, there are a variety of jobs here. I mean, there's at least 10 different categories here, different jobs, and each category has a number of jobs. Clearly, the 10-page document he produced had even a more in-depth description of all the variety of things he did. But yes, this is very consistent.
And you mentioned that Mr. Murphy was treating with Dr. Wyrick, the chiropractor.
Correct.
During that time. Do you know what he was treating with him for?
He was treating for him for his back, neck, and I believe also for his legs he was treating for him, but not anything to do with his wrist or hands. Okay.
And how long did Mr. Murphy continue to treat with Dr. Wyrick?
He's been treating with Dr. Wyrick. I believe he told me, I know he's been a chiropractic treatment since 1998 when he first saw us. I'm not sure that was Dr. Wyrick at the beginning or not, but he has been in treatment for chiropractic problems for at least, 20-some years. And I know that he's been seeing Dr. Wyrick since 2015, if not earlier.
And did that treatment continue after he returned to work in June of 2015 and started driving the lawnmower?
Yes.
After Mr. Murphy had the EMG on July 3rd or 2nd of 2015. Do you know when the next time Dr. Wyrick refers to any issues regarding Mr. Murphy's wrist was?
I think the first time, according to my records here, which I'm going to refer to my report because I know I asked that question. I think it was I believe it was May 18th of 2016.
So the following year?
It's over, almost a year later. Not quite.
I'm going to show you what's being marked as Defendant's Exhibit C. Have you seen this record before, Doctor?
I have.
Could you tell the jury what it is?
So this is a chiropractic letter from, excuse me, from Dr. Wyrick, dated May 18th, 2016. And now, excuse me, he's writing, thank you, he's writing a report where he's requesting that the claim be allowed for that there be a claim allowed for bilateral carpal tunnel syndrome on the basis of an occupational disease, and he wanted referrals, and he wanted to do testing and perhaps treatment, and he wanted to do chiropractic treatment.
Are you aware of whether Mr. Murphy was working for the city of Painesville at that time in May of 2016?
He was not.
Do you know why he was not working at that time?
He chose to retire after 31 years.
And do you know when his retirement date was?
I believe it was January 1st of that year.
Of 2016?
Correct.
Okay, so this was about 5 months after he retired?
He told me it was about 6 months later that he saw Dr. Wyrick. He said not quite, yes.
And to your knowledge, is there any medical record of any treatment between the date of the EMG on July 2nd of 2015 and this visit with Dr. Wyrick on May 18th of 2016?
No, there's no medical records of any treatment.
And if you take a look at the onset and mechanism of injury part of this report at the top, how did Mr. Murphy indicate the course of his symptoms had happened?
Well, he has a couple theories here that are listed here. He's not clear. On one hand, he said, yes, he has, the chiropractor says, yes, he has a demanding physical job that he's been doing for 31 years. However, he really only had symptoms that began in June of 2015. And before that, even though he had quote, a hard job, it was only when he was riding the mower in this very short period of time that he developed his carpal tunnel syndrome.
Okay, Doctor. In the history you obtained from Mr. Murphy and the records and your exam findings, what information did you find to be of particular significance?
Well, just to summarize, what's significant is he had a job that involved a whole variety of activities that he did on a rotational basis. Nothing was consistently repetitive or let alone highly repetitive. If you look at this 10-page recitation of what he did, he would do this sometimes and that sometimes, go back and forth, seasonally different, weekday different. So the fact that he had so much in the way of job rotation is very significant. There's nothing that was highly repetitive that could be tied to his work-related activities. That's number one. Number two was he did this for decades until he actually complained to somebody in 2015. And when he went in for the EMG, it was not really because of his hands. They thought he had because of the MRI scan of his neck that he had some compression in his neck. So when we did the EMG study, it was mildly abnormal, suggestive, I don't believe diagnostic. That was important to understand. Also, his examinations, as far as I can tell from the records, because he really never had any to 2015 and then nothing to 2016, they were not diagnostic. He didn't really have what looked to be carpal tunnel. When I saw him, as part of your question, he clearly did not have any consistent signs and symptoms of carpal tunnel. His exam was basically normal except for his group strength, which was highly variable and not really relevant because he wasn't trying as hard as a normal exam. It was not consistent with carpal tunnel. On top of that, his symptoms, which is not just numbness and tingling, but it's the fact that it usually gets worse at night, that it's usually in just these three fingers. It's usually something that you can elicit with certain signs and symptoms or certain activities. He didn't really have any of that. So what I find impressive is that he had job rotation. He didn't have a consistently highly repetitive job. His symptoms were very vague and not really consistent with carpal tunnel syndrome. The EMG study, nerve conduction study showed mild, only nerve sensory mild abnormalities. It was not really full-blown carpal tunnel. His clinical exam never was consistent with carpal tunnel. In particular, I saw was definitely not consistent. His symptoms, even through the years, when you ask him about his symptomatology, also is not really consistent with carpal tunnel syndrome. So in summary, I would say, number one, I don't think he has carpal tunnel syndrome. If I were evaluating him for insurance companies, which is what I do on a regular basis, he doesn't have sufficiently medical evidence with a reasonable amount of certainty with what everything I just said that would lead to the conclusion he has carpal tunnel, number one. His job activities were not consistent, causing carpal tunnel syndrome. And because of that, I don't think he probably has carpal tunnel syndrome. He's certainly not related to the job.
And doctor, if a person has experiences symptoms that are being caused by certain activities, would you expect those symptoms to alleviate or resolve when they are no longer doing those activities?
Typically, that's true. That's another good point. Thank you. Yes, if he believes it's due to the job, then when he doesn't do any work, he shouldn't have the same degree of symptoms. He may have some nagging discomfort, which I have seen, but to have exacerbation of the immune activity is very common. He doesn't have that. It's just, in fact, when I asked him that question, he just said, well, it's just the general amount of activities he does, and here's my 10-page list of everything I do, and that's why I have carpal tunnel. Not true.
Doctor, based upon your qualifications and experience, your examination of Timothy Murphy, the history you obtained from him, and the histories and test results contained in the medical records you reviewed, do you have an opinion based upon a reasonable degree of medical certainty and probability as to whether his bilateral carpal tunnel syndrome was caused by his employment with the city of Painesville? First, do you have an opinion?
I do.
And what is your opinion?
Well, first, I would not say he even has carpal tunnel syndrome. I don't think the bulk of medical evidence can allow one to make that diagnosis a reasonable degree of medical certainty. Number two, even if you assume he does have bilateral carpal tunnel syndrome, mild as it is, his job activities clearly are highly rotational, not repetitive, and are not the cause of any such diagnosis.
And what are the reasons for your opinion?
Just to summarize, I don't want to bore you to death, his work activities are not consistent because of the amount of rotational and different things he did. His clinical symptoms that he describes to me throughout the years also not consistent with carpal tunnel syndrome. His physical specific findings have not been consistent with carpal tunnel syndrome. They have some aspects that may be, but in general they were not. His Eugene nerve conduction was slightly abnormal, but if you look at how it was abnormal, what it was abnormal, it's an issue to consider, but it was not highly diagnostic of this. Put that all together, not to mention my examination of him, and there's no basis for the diagnosis with a reasonable medical certainty, nor is there certainly any basis for tying it into his work activities.
Doctor, based upon your qualifications and experience, your examination of Timothy Murphy, the history obtained from him, and the histories and test results contained in the medical records you reviewed, do you have an opinion based upon a reasonable degree of medical certainty and probability as to whether his employment with the City of Painesville placed him at a greater risk of contracting carpal tunnel syndrome than the public in general? First, do you have an opinion?
Yes.
What is your opinion?
No.
And what are the reasons for your opinion?
Well, I won't, as I said, I'm not going to bore you to death. He had a lot of job rotation. I mean, he had a job that I would envy in some cases to put in place in different companies when I was a consultant because there was so much rotation. This is the kind of position that I would detail to prevent carpal tunnel syndrome in companies. So I don't think there's anything at this particular job he did which was quite far-ranging what he had to accomplish that led to carpal tunnel syndrome. The people that knit and do other kinds of activities at home, hobbies, etc., that are more prone to get this than he would be based upon his job rotational activities.
Okay, and Doctor, you indicated that you reviewed records from Dr. Justin Wyrick, Mr. Murphy's chiropractor in this case, is that right?
Yes.
What's the difference between a chiropractor and a medical doctor?
Chiropractors really focus on joints, musculoskeletal issues. They are not trained in like internal medicine and looking at all the other things, for example, that can cause carpal tunnel syndrome, such as endocrine abnormalities, cardiac abnormalities, fluid redistribution, autoimmune disease, arthritis, rheumatological disease. These are not within the purview necessarily of the chiropractor. Only the musculoskeletal is really their focus.
And carpal tunnel syndrome is a neurological condition, is that correct?
It's a combination. It can be neurological, it could be orthopedic, but it also has some, you really have to understand the internal medicine aspects of people with diabetes, with hypothyroidism, congestive heart failure. There's a lot of reasons for that. And an MD really has a much broader perspective at looking at this issue than perhaps just a chiropractor.
And are there things that a medical doctor can do that a chiropractor is not permitted to do?
Sure, we can inject, we can prescribe medication, we can often hospitalize when they don't. There's a lot of things you can do as a doctor that chiropractors cannot do.
Do you agree with Dr. Wyrick's opinion regarding the relationship between Mr. Murphy's employment and his bilateral carpal tunnel syndrome?
Never wrong.
Thank you, Doctor. I don't want to think further at this time.
Hi, Doctor. Nice to meet you. My name is Corey Kuzma. I represent Mr. Murphy in this matter. It's actually good to meet you face-to-face. I've read your reports for years, so it's always good to put a face to the name. I just have a few questions regarding this matter that we're in court for. Doctor, you first examined Mr. Murphy in April 2022, correct?
It's the only time I saw him, correct.
That was going to be my next question. That's the first and only time you ever met with, spoke, and examined Mr. Murphy?
Yes.
Okay. And you mentioned before about his retirement date. Do you remember what that is offhand?
I remember what he told me. I wrote on my own handwriting. He told me he worked up to 1/1/16, and that was his retirement date. This is his words.
Okay. Is that in your report? In your report, I have December 31st, 2016. But I think we can all agree it should be December 31st, 2015.
Yeah, it's a typo. That's what it says.
Okay, just making sure. So the first and only time you saw Mr. Murphy for an examination was roughly a little over 6 years after he retired from the City of Painesville.
Correct.
In reviewing your April 11, 2022 report, I noticed you stated that at that time you only believed Mr. Murphy may have bilateral carpal tunnel syndrome, correct?
I'm not sure what you mean. I told you I believe that more likely than not there's not sufficient medical evidence with a reason or certain to say that he actually had bilateral. So I used the word may.
Well, I'll read from your report, when you were asked the question whether Mr. Murphy sustained the condition of bilateral carpal tunnel as a result of his employment with the city of Paynesville.
I'm sorry, which page are you on? Are you on page 10?
It is the second to last page.
Right, page 10.
Question number 1.
Right.
Your response was, the individual may have bilateral carpal tunnel syndrome. And then you went on to say, from a clinical perspective, he has weakness, but no positive tendal sign or positive fennel signs. His range of motion is basically normal, correct?
Correct.
But it's your testimony today that you don't believe he has carpal tunnel.
Well, my testimony then, if you look at page 11, it says, as such, the conclusion is that the bulk of evidence at this point in time does not confirm bilateral carpal tunnel syndrome as being more likely than not. So what I said today is very consistent with what I wrote.
Okay. So, and that, your opinion, that's still despite an EMG from July 2nd, 2015, confirming that Mr. Murphy has mild bilateral carpal tunnel syndrome, according to the EMG.
The EMG is a tool in your kit, and the EMG, you have to look at all aspects of the EMG before you say that it's not a definitive diagnosis. What Dr. Weinberger says is that he may have mild bilateral carpal tunnel syndrome based strictly on the sensory nerve aspect of it. Because the motor is normal, there's no fasciculations and no fibrillations. You have to look at everything. This is a very mildly abnormal test, if you would. It's not by itself diagnostic, which is why I came to the conclusion that the bulk of medical evidence, despite this EMG, does not mean he has carpal tunnel syndrome. I still believe that.
Objection. I'll just ask you, Doctor. The EMG, though, did you review it yourself personally?
I'm not sure what you mean. I reviewed the report. You cannot actually review an EMG. It's a dynamic test where you are looking at an ultrasound or a scope, and it's generally not recorded, so you can't review it. You have to just review the report.
Okay. And the report from the reviewing doctor confirms mild carpal tunnel syndrome, correct?
Well, the report has an impression.
Doctor, I'm just asking for yes or no.
It does not confirm. It expresses.
Expresses.
It's different.
And Doctor, you said you reviewed, I know it was exhibit letter C, Dr. Wyrick's report.
I'm sorry, I don't have mine listed as exhibit number, so tell me which one you're referring to.
Yeah, it's Dr. Wyrick's report from May 18, 2016. It should be on his second page.
This is the second page of what? This one here, yes. Got it.
Okay.
You have a question?
I do. You testified before that one of the 3 factors you like to see in possibly diagnosing carpal tunnel syndrome is a variety of tests, correct?
Not exactly. I said that's not what I said. I said there's 3 aspects to it. One is the history, the medical history. The second is the actual clinical findings. The third is ancillary tests, but actually the fourth is also what the job is too. It's all those things.
So in the second one, the findings, you testified the Tinel test, if I'm pronouncing that correctly.
Tinel test, yes.
Okay. And I can give you my copy I highlighted. You said you reviewed Dr. Wyrick's report, but he did find positive Tinel's test, Phelan's test, and Finkelstein's test, correct?
Let's see, Heiberger, I can see. Yeah, he says he did.
Any reason to believe that those tests weren't done correctly or that they were inaccurate or falsified?
Well, let's see here. Yeah, this is the only letter I see that in, and when I saw him, he clearly did not have it. I don't see it by Dr. Weinberger or anybody else listing the same thing. So this is the only one that I see that he put in, and I just don't believe it.
And actually, a follow-up question: why you just testified that you don't believe it? What do you mean by that?
It's out of context with the other findings and the other symptoms that he had or didn't have throughout the years, the people he saw, etc. This is a one report where he wrote in a letter, but in his clinical notes before this, there's nothing to say that he had this ongoing. This is a one-time exam that he saw that. And I don't see that anywhere else. When I saw him, he told me that even though it's 6 years later since he retired, it's not gotten better. He feels the same now that he felt when he felt in 2016. And he clearly had none of the findings that Dr. Weyer purported to have noted when he examined him.
And just so we're on the same page, the first doctor, Dr. Weisberger, he did not have with that EMG any physical examinations or testing for Mr. Murphy, correct?
Well, let's back up. There's a Dr. Weisberger that you just showed me today, a report, and there's a Dr. Weinberger. Which one are we talking about?
The one from June 2015.
That's Dr. Weinberger, not Weisberger, right?
Correct.
So you misspoke, right?
If I did, I apologize. I'm just asking if there was any.
So the question now is, can you show me the report you're talking about? If you just make sure I'm on the same page you are.
Sure. So it was labeled Exhibit A. It's from June 3rd, 2015.
Okay, yeah. This is Dr. Weinberger, not Weisberger.
Okay. There's no negative. Scratch that. Strike that. Doctor, is there any physical examinations that the doctor did for Mr. Murphy in regards to carpal tunnel?
He did, on a physical examination, he did a sensory exam, did a motor exam. The sensory exam, he purported to have done touch pin and vibration, all of which were normal. He didn't find the same things that, obviously, that Dr. Wyrick, the chiropractor, found. So that part, even though it doesn't label it as carpal tunnel exam, and that is part of the carpal tunnel exam. Same thing with his motor exam, too. All that was normal.
And Doctor, I'll just ask you, are you aware of any treatment Mr. Murphy has had for carpal tunnel after Dr. Wyrick's report 2016 up until you saw him in April of 2022?
I'm not aware of any treatment he's ever had, actually, before or after.
Okay. So I'm going to hand you what's been labeled as Plaintiff's Exhibit 1. And can you look at that and just tell the jury generally what it is?
All right, this is a record you just gave me today by Dr. Michael Weisberger, which was seen when he saw him. He's an orthopedic doctor, saw him 3 times, 7/18, 2019, 10/31, 2019, and 2/13, 2020.
And I know you answered part of it, but you did not see those records in your review and report of Dr. Murphy in April 2022 of this year, correct?
Correct. You gave them to me prior to his deposition. You gave me an opportunity to read through them prior to his deposition today.
So obviously those were not taken into consideration when you gave your opinion, at least in your report from April 2022, correct?
That is correct.
Okay. And obviously you read the dates off. I think they were July 18, 2019, October 31st, 2019, and February 13, 2020. Does that seem correct?
It seems exactly correct, yes.
Okay. And those are all obviously before you examined Mr. Murphy of this year?
Correct.
Okay. And looking specifically at the July 18, 2019 record, it's just the first page, Doctor. Can you review that and let me know if there was a positive Tyndall test, positive Durkin test, and a right hand, I'm sorry, just if those were the 2 positive findings in that examination?
He does break that down on that exam, the first one, that it's a positive Durkin and a positive Tyndall.
And it should still be on the first page, Doctor, but can you tell me what treatment was rendered to Mr. Murphy at that time?
No treatment. He injected his thumb. He had a significant arthritis in his thumb unrelated to his wrist, and he injected the thumb. That was the only treatment he gave him.
Okay. When you met with Mr. Murphy this year, did you ask him if he had any kind of treatment for carpal tunnel?
I did ask him that, and I asked him also if in this report, for example, he has listed under functional status a series of symptoms, which I asked Mr. Murphy about, and he denied these same symptoms that apparently are listed here.
Do you remember if you asked him specifically if you've ever had any injections for carpal tunnel?
I did ask him any treatment injections. I think he used a wrist brace at one point in time. I'm not sure if his water was prescribed, but he did have injections where his thumb, not in the carpal. You can inject the carpal ligament, but you also, his problem was really his thumb, where he had the cinnamon place. That was the part injected, not his carpal area.
Do you recall in your report where you discussed the injections in his thumb?
Not offhand, let me see. I don't think I actually went into his thumb issues here in my report. I talked about his potential carpal tunnel, but not his thumb.
Yeah, I didn't see it either, so I just wanted to ask just in case. Doctor, just generally, would you ever prescribe or I'll say recommend an injection to a patient, even if it is in their right thumb, if you believe they had carpal tunnel syndrome?
I don't understand your question. We're talking about two separate issues. We're talking about osteoarthritis of the thumb. At the primary joint here, there's a couple places you can have it. That's completely different than carpal tunnel, and I do have recommended injections there, and I've done those injections when I see that, if that's your question.
Well, I'll ask in a different way, I guess. If someone had carpal tunnel syndrome, would an injection in their thumb ever help alleviate any of the symptoms related to that?
If there's symptoms were due to carpal tunnel, no.
Doctor, just stepping away from Mr. Murphy for a second, I know you testified before you were asked to examine and write a report on behalf of the BWC from Attorney Nimrick, is that correct?
Yes.
How many times in a given typical year do you produce reports and examinations for the BWC?
Well, nothing's been really typical the last 3 years, to tell you the truth. So let me talk about before that. Before COVID, it was different. I don't do that many anymore. I mean, maybe in the last 3 years I've done, I'm sure, less than half a dozen at the absolute most in terms of working with the Attorney General and the BWC. I've been asked by the BWC as a specialist to actually see people that are injured. That happens also occasionally. I've been asked as a specialist by the BWC to evaluate people and offer my opinion as to if it's related or not. I actually do that much more regularly, chart reviews. I probably do that one, maybe even 2 or 3 times a month. I'm asked to opine if somebody has a condition that should be allowed or not allowed. But in terms of, I'm not sure I understand the question, in terms of making it to the area where we're doing work with the Attorney General, such as Attorney Nimrick, that's been rare. It's been less than 5 times in the last couple of years.
You're talking about trial depositions then?
Yeah, I guess this is what this is. Well, this is actually a trial deposition. Yes, that's what I'm talking about.
And I apologize if that was a loaded question then. In a typical year, how many IMEs do you perform in a typical month?
Well, there's nothing typical, including, forget about the Bureau for a minute. For probably, I don't know how to answer your question, for well over a year I didn't see any patients at all, whether it's exams, whether it's BWC or whatever. And then probably last October, the backlog of, and I'm sure it's the same for you as an attorney, things changed, and suddenly I had not done depositions for some time, and then suddenly all the judges demanded depositions, so I've done depositions and IMEs probably since then. I don't know how many, because it comes and goes a little bit dependent upon COVID. But it's not infrequent now as people try to catch up.
Okay, and I'm not trying to trick you in any way.
I'm trying to be straight
before COVID then, 2019, in a typical month, how many IMEs, not trial depositions, IMEs would you perform?
I don't remember. I mean, you have to realize also, I do a lot of consultative work. I will go to companies and write up their policies, procedures, respond to incidents. Sometimes it'll be the whole month. I'd have a few projects. I won't do any IMEs and see very few patients. There's some months I would do a lot of clinical work and I'd see patients. It's been like 4 years. I'm not even 3 years at least. I'm not exactly sure of the numbers.
And I'll ask you, because normally, or at least sometimes, there's notes on an IME about how long the doctor spent with the client or the patient, how long they reviewed the records for, and how long it took them to actually write out a report. Do you remember how long you actually spoke and met with Mr. Murphy for?
It was about 2 hours. There are bills I've sent to the Attorney General's office about exactly how many hours. I don't have them with me, but there are bills I've produced, which includes review of the records initially, the IME initially, then I got more records, I issued an addendum, and then I got more records, which I do not necessarily issue an addendum, including today. So I do track my hours. I don't know offhand how many hours altogether.
When you said 2 hours, is that 2 hours with Mr. Murphy, or do you think that's 2 hours reviewing the records, talking with him, then writing a report?
No, 2 hours is with him. There's a lot more hours involved in looking at the records and writing a report.
So you actually spoke with Mr. Murphy for about 2 hours?
Probably between an hour and a half or so. I don't remember exactly. I may have it written down here. Let me see. Sometimes I write it down. Not always, but let me see. I will tell you this, and I'll just offer this, is that typically the exam part is much less than talking part. And Mr. Murphy's a loquacious individual, so he had a lot to say, and then he had a lot to go over in his work activities, which he shared with me prior to even giving me the extensive report he gave me. I don't actually see where I wrote down the number of hours spent.
Going back to specifically Mr. Murphy, I know you testified before. To your understanding, he worked for the city of Painesville for 31 years, correct?
Yes.
Okay. And we can at least agree that he did work with vibrating power tools pretty consistently in his job, given the description that he gave you, given the conversations you had with him, and Dr. Wyrick's report as well, correct?
I'm not sure what you mean consistently. He used them intermittently. There's a variety of different machines he used. Everything from jackhammers to chipping to lawn, those things that spin around, the trimmers, to lawnmowers. He had some of the machines did have power, but there's a whole variety of machines. In his report, he goes into them much more in depth. He tamped things, he trimmed things, he graded things. He did a whole variety of things with a whole variety of different machines intermittently. So that part is true, but I wouldn't say consistently and highly repetitively.
Doctor, I noticed your report from April 11, 2022, the only power tool that it notes is a jackhammer. Does that seem correct?
No, it does not seem correct. It's incorrect, actually.
I'm just looking
He said he uses sledgehammers, chipping and brushing tools, jackhammers, lawn maintenance with power tools, and edgers and trimmers and machines. There's coal tar patching, hot patching. Tony uses machines for that also. And then we had this discussion. He said, I'm going to give you a much more detailed history of what I use in the machines. And indeed he did. He gave me a 10-page, really shortly after, a 10-page description of all the things that he did do. which I read and which I was aware of.
Then, Doctor, I'm just going to ask you, because Dr. Wyrich's report notes some other power tools that aren't in your report. As I said before, you noted jackhammers. We can agree that's in your report, correct?
Correct.
Okay, what about chainsaws?
Occasionally.
Is that in your report?
No.
Do you know what a tamper is in terms of?
Yeah, it's a machine that tamps. It's a power machine that tamps on the asphalt. You hold it in 2 hands.
And that's not in your report?
Listen, he has 10 pages of things he did. None of these are my report. All of these I received right around even before I wrote a report. And because it's March 29th, I waited till I got this, but I didn't include all 10 pages. I was aware of everything he did. I testified now on what he did. I was aware of some of the machines and the rotational way and how he used it and how long he used it. And I didn't put all 10 pages in my report, no.
Do you know the difference between a handheld tamper and an electric one, Doctor?
Well, my understanding is there's a couple kind of tampers, and it's not just from him. I'm not sure what the city had, because I've been the medical director of various cities. There are the ones that are diesel powered, there are ones that are gasoline powered, there's ones that are electric powered. I don't really know ones that are actually, and there are ones I guess that are hand powered too. You just tamp. You don't really have any assist.
Do you know offhand, or reading your report or any of the records, which one Mr. Murphy used when he was at the city for 31 years?
He would occasionally use a tamper. He called it a root handle tamper. He has 3 pages of stuff, all the different things he did, carrying buckets, carrying equipment, running the machines. No, I don't know. He didn't actually lay out exactly what the brand was and what fuel it used.
Doctor, I know you testified before, and you brought out your carpal tunnel syndrome poster board as well. And I wanted to ask you, in regards to that, in your testimony, the risk factors of carpal tunnel. It's my understanding that there are multiple factors of carpal tunnel, including thyroid disorders, rheumatoid arthritis, hormonal replacement therapy, diabetes, if someone is pregnant or on menopause, smoking, obviously, probably most relevant, repetitive work, and or direct trauma to their wrists or forearms. Is that correct?
Not really. Though some of those things are indeed true, it's not obviously, and most importantly, that it's cumulative trauma. There's a lot of controversy if doing certain activities lead to carpal tunnel or not. So your characterization of that as being obviously is not true. There's numerous articles written. But assuming somebody does have a highly repetitive job, it also depends exactly the kinds of activities you do and how much they stretch the ligaments, how frequently, how much job rotation, and a number of other factors that will go into it. You mentioned some of the other predisposing or associated issues such as diabetes, hypothyroidism. There's also autoimmune disease. There's a whole list of things I can give you, including medications. And keep in mind that half of the time people get carpal tunnel, we don't know why. We have none of the either job activities and we have none of the medical conditions that you just mentioned, and half the time.
Okay, but those are the factors that I listed. Those are ones that are generally factors of why someone would develop carpal tunnel. Is that fair?
They're associated with it. They're a subset, not a comprehensive list of things that can be associated with carpal tunnel.
Okay. And do you know if those are, reading your poster board over here, the risk factors, those are pretty much the ones I listed as well at the bottom, correct? I might have missed one, obesity.
Yeah, that's the things I list here. This is a poster board. This is not an academic treatise, nor is it based upon 35 years of experience doing this. But yes, those are listed there.
Doctor, can we agree Mr. Murphy has never been diagnosed with any of those risk factors that we just went over?
The few that you mentioned, no.
And And Doctor, you brought up a few times during your testimony and in your report, you mentioned Mr. Murphy has a number of other medical problems and a number of other complaints to other extremities, correct?
Well, he has complaints in both of his arms and both of his legs, if that's what you mean. He does have a number of other unrelated diagnoses, that's true too.
Well, I guess the main point of my question would be, any other medical issues? We already agreed that he does not have any diagnosis from any of the risk factors we went over. But any of the other medical problems that he has, those aren't attributed to carpal tunnel, correct?
I'm not sure what you mean. He has a number of medical issues, including a heightened propensity for deep venous thrombosis, as well as bleeding because of his platelet abnormality, high blood pressure, high lipids, Van Willebrand's disease. He has had pulmonary embolisms and dyspnea. Has been on different medications. I didn't look at all the medications to see their relationship with carpal tunnel syndrome. What I primarily focused on the fact that his job activities and what he did in his symptomatology and findings were not consistent with carpal tunnel syndrome based upon his work activities, or even carpal tunnel syndrome.
Well, I'm just trying to get any kind of clarification. The second last page of your IME, question 1, your response, the 4th paragraph down, when answering the question whether or not Mr. Murphy has bilateral carpal tunnel as a result of his employment with the city of Painesville, you said he has a number of other medical problems and a number of other complaints related to extremities. Can you tell me any other medical issues or any other complaints that you attribute to him having or not having carpal tunnel?
Right, but if you read the whole paragraph, you just read part of it. It says in order to even make the diagnosis of bilateral carpal tunnel syndrome at this point, or PEMG, nerve conduction studies should be done to verify. So what I meant by that whole paragraph is that he already has an abnormal MRI scan of the cervical spine. At the time they did the EMG, yes, he did not have any radiculopathy. That was 7 years ago. His complaints now, in my opinion, could well be due to that because he clearly did not have anything that was really consistent with carpal tunnel syndrome. That's what this was about, and that's why I wrote this paragraph.
Can I ask you, so your opinion, is it limited to whether or not you think Mr. Murphy has carpal tunnel syndrome, bilateral carpal tunnel syndrome, in 2022 as opposed to 2016 or 2017?
No. It's not limited to that.
Even though you're saying in your response that a repeat EMG study should be done to verify this is what he has going on.
Well, I said that Mr. Murphy told me his symptoms really were no better than they were in 2015. He had the same, if not worse, so nothing had changed. He told me that in terms of his complaints, nothing had changed. What you showed me from 2019 now confirms that he had ongoing symptoms. And despite all that, so he has not had a change. So what he had in 2015 from a symptom perspective is still the same that he has now. In fact, it's even worse if you ask him. But his examination clearly shows him not to have what I believe is the bulk of evidence supporting carpal tunnel syndrome. He does not have, when I saw no tenants, no failings, even though he had the same complaints. He had variable weakness and nothing else beyond that. So I don't think my opinion is confined only to now. It goes back to 2015.
And going back to those 3 ways, general ways to diagnose carpal tunnel, the symptoms, the findings, and the EMG. You testified before, and it's in your report, that you saw no classic signs of carpal tunnel, such as awakening at night or fatigue with overuse. Is that correct?
Exactly what he told me when I saw him now.
Okay. If you could look back at Dr. Weirach's report, May 18, 2016,
I just had it. Can you find
I
it?
think I gave you my exhibit copy.
How generous of you. Let me see if I can find it. Yeah, okay. It's here, I'm sure. Here it is. Is your exhibit copy? Go ahead.
It's page 2,
May 18th, right?
May 18, 2016, yes. Page 2, at the bottom, near the bottom under physical examinations. I'm sorry, under presenting symptoms. You can find it in your copy if you want. I highlighted mine. I wanted you to read starting from that sentence, just what I highlighted.
The patient stated that he continued to drop objects with his right hand. He noted that switching hands, and he feels the presence of fatigue or paresthesias. He described pain referral from the volar aspects of the wrist to the distal aspects of the first to third digits, identifying the thenar region in first and second interspaces as a source of pain. He described tightness. He said repetitive stress activities are more provocative and sustained grasping activities involving the hands and wrist. He represented he had at least 5 out of 10 on the right and 3 out of 4 out of 10 on the left.
So we can at least agree that, at the very least, Dr. Wyrick noted fatigue in Mr. Murphy's hands and the needing to switch hands with use, at least in May of 2016.
That's what he wrote.
Do you remember reading that before you wrote in your report that there was no findings of fatigue at all?
I did.
All right. And Doctor, going back to Plaintiff's Exhibit 1, I believe you still have that. It's Dr. Weisberger's.
Just tell me what it is.
Right here.
The one you gave me today.
Yes.
Well, let me get the whole thing.
Yes, and I won't have you read the whole thing. I didn't highlight, I put a little post-it notes where I wanted you to read. And I will, for your sake, also saying for the jury's sake and everyone's, that there's some bad grammar in here. But I wanted you to read that just to see if that is in relations to any of the Mr. Murphy having trouble sleeping due to his carpal tunnel.
Can we read it?
If you could read starting with...
I can read what you marked off. He noticed he had some issues with carpal tunnel off and on in his hand for several years, about 4 or 5. He had a fall a couple of months ago, and he has since then a lot of pain in his wrist and the thenar eminence. He's really not done a whole lot. He states he's limited what he can do secondary to his primary platelet disorder. He's taken multiple other medications for a previous lower extremity injury, but they don't help his hand. He has used a wrist brace, which helps with the carpal tunnel syndrome, but not his thumb. He denies treatment for hands and fingers. He denies locking and triggering. He states his hands frequently fall asleep on and off during the day. They wake him from sleep that night. He awakens from sleep that night. He has difficulty holding on small objects. I reviewed the past medical medication surgeries and social history.
So that at least that note from Dr. Weisberger at least notes at that time that it seemed Mr. Murphy was having some issues sleeping due to his hands. Is that fair?
That's what he writes, yes.
Okay. And you didn't see these records until today, correct? So you didn't take that into consideration in the report?
I had Mr. Murphy right here. I asked him those questions. I asked him, your hands fall asleep at night, your hands waking in the evening. He did say he dropped things from time to time, but he didn't give the other classical history. He didn't radiate into his fingers, particularly the 3 fingers we talked about. So I asked him all these things. So yes, I did not have this, but he gave me direction in his own verbiage, something that's not exactly the same as written here.
And that was going to be my follow-up question, because in your report you said he has no classic signs of carpal tunnel syndrome, such as awakening in the evening or fatigue with overuse. You say you asked him that. I don't see in your report that he denied that you asked him and he denied having those issues.
I wrote that because that's what he said.
Just a few more questions, Doctor. Given your opinion, obviously you don't feel the carpal tunnel, even assuming that it is there, it's not related to his work duties with the city of Painesville. I didn't notice in your report you noting any other factors or any other reasons why you think he might have carpal tunnel. Is that fair?
I don't understand the question.
So for example, well, I'll reword it. There's nothing in your report that would attribute his carpal tunnel or possible carpal tunnel to anything, any other activities, such as any other hobbies or any specific medical condition, as opposed to him having carpal tunnel from his work duties.
When I did this report, my focus was on, number one, did he have carpal tunnel syndrome? And I came to the conclusion, as we just read, including my initial report, that the bulk of evidence did not support carpal tunnel syndrome. So I did not delve into potentially there's a whole list of things that one could look at. I did not delve into it or address it. That was number one. Number two, even if one assumes he has mild carpal tunnel syndrome, the real question was, is there anything in the activities he did that would be causative of that? And clearly, in my opinion, as I've expressed numerous times in this deposition, no. So that's what my focus in my report was, not to explore the universe of what can cause carpal tunnel syndrome, but to see if he had it, and if he did have it, in the hypothetical, was it due to work activities?
So you wouldn't think it would be important to consider, assuming he has carpal tunnel, any hobbies or activities outside of the workplace that could cause that? You don't think that would be important to note or take in consideration in your opinion?
I wouldn't say necessarily, but I think what's much more relevant is what I just talked about. It's his work activities, what he did, how he did it, and how frequently, and what their devices that he used. That was much more relevant. And as I said, I didn't do a whole treatise on carpal tunnel syndrome and what else can cause it. I mean, I have written papers about that, but not in this particular case. I focused on what was relevant.
Stepping away from Mr. Murphy for a second, if someone went to you and you were if someone went to you for a consultation and it was clear to you that they had carpal tunnel syndrome, would you ask them the difference between their work activities and any outside of work hobbies that they might have in order to pinpoint where their carpal tunnel came from?
Oh, yes, I probably would, if that were the focus of what I was doing.
But again, you didn't ask Mr. Murphy what his hobbies were outside of work.
I didn't get into that because I didn't think it was relevant, and he didn't mention anything offhand, and I didn't spend a lot of time delving into that because I didn't think that was really the focus of what I needed to say.
Let me just check my notes real quick to make sure I went over everything. Actually, we can go off the record for just a second. Great. Doctor, I reviewed all my notes. Those were all the questions I had for you today. I appreciate your time and the response.
Thank you. Thank you. I appreciate the intervention here on behalf of your client.
Thank you. Doctor, I just have a few follow-up questions based on what Mr. Kuzma asked you. Have you had occasion to see or treat patients or provide reports on behalf of Mr. Kuzma's law firm over the course of your career?
I have.
You had some discussion about the causes of carpal tunnel syndrome. Does the risk of developing carpal tunnel syndrome increase as we get older?
It does.
And is that the case with or without any job activities or medical conditions that Mr. Kuzma listed?
Yes, as I said, at least half of the cases of carpal tunnel, we do not have a cause. No matter how extensively you look at work activities, at hobbies, at associated diseases, we just don't find a cause, and it happens.
And would injections to the thumb typically be done as treatment for carpal tunnel syndrome?
That's completely unrelated. He had arthritis of the joint here, and that's the treatment for that, and it has nothing to do with carpal tunnel syndrome.
Okay. And with regard to the records, Mr. Kuzma showed you from Dr. Weisberger from 2019 and 2020. How long after Timothy Murphy retired were those treatment records?
They were over 3 years old, 3.5 years old. to 4 years old.
And I'm going to refer you just quickly again to Plaintiff's Exhibit 1, the record from Dr. Weisberger. Looking back at what you had read for Mr. Kuzma, is there an indication that Mr. Murphy had a recent, at the time of this July 18th of 2019 record, that he had a recent fall?
Yes.
And had that affected these findings in his hand?
Yeah, he said he's had the same issues for 4 or 5 years, but after his fall, which was a couple months before that, he had a lot of pain in his hand and fingers.
Does anything in these records from Dr. Weisberger that you saw today change your opinions in this case?
No, not at all.
Okay. And there was also a lot of discussion back and forth about whether or not Mr. Murphy actually has or had diagnosable carpal tunnel syndrome. Assuming that he does have carpal tunnel syndrome or had it back in 2015 or 2016, would it have been caused by his employment with the city of Painesville?
No, not at all. I mean, as I said, his 10-page job recitation, all the things he did, all the machinery he used, all the different devices, and his tools that he used were actually a prescription for a job rotation, physical demand type of position, which I would have put in place. I mean, what he did is clearly designed, what the city did, whether intentionally or not intentionally, was all done to prevent carpal tunnel syndrome. He had enough rotational activities and enough job variation. None of this would rise to highly repetitive activity.
Thank you, Doctor. I have nothing further.
Just a quick follow-up question or two, just based on what Attorney Nimmer asked you. In regards to carpal tunnel and age, you said someone who is older would be more susceptible to getting carpal tunnel. Is that fair?
Typically, as you get older, you have associated issues, arthritis, osteoarthritis, which he had. You can also have retention of fluid, which many people have. There's a whole variety of things that increases the incidence.
And again, Mr. Murphy worked for the city for 31 years. Do you know how old he was when he retired?
Well, with a calculation here, I can tell you exactly how old he was. Let me just see. So he was born in 1958. He retired in 2000, the end of 2015, actually almost on the day of his birthday. That would make it 42 plus 15 is 57.
Thank you, Doctor. Those are all the questions I have.
You're welcome.
Okay, ladies and gentlemen, I'm going to give you a short break, and then when you return to the courtroom, I'm going to give you the instructions of law. The attorneys will argue the case, and then I'll give it to you to decide. At that point, you can take your lunch and in whatever manner you see fit. So it'll only be about 5 minutes.
All rise for the jury.
Records reflect that the jurors have left the courtroom, and defense rest.
Yes, Your Honor, given that you've admitted the joint exhibits 1 through 6, the defense will rest.
Okay, you're not offering A, B, C, and D?
All the ones from the depot, they're incorporated in the joint exhibits.
Oh, they're in with the joint
Yes, they
exhibit.
can be covered.
Okay. permitted to change the law or to apply your own idea of what you think the law should be. The person who claims that certain facts exist must prove them by a preponderance of the evidence. This duty is known as the burden of proof. The burden of proof is on the plaintiff to prove the facts necessary for his case by a preponderance of the evidence. Later, the court will outline and explain the factual issues. Preponderance of the evidence is the greater weight of the evidence, that is, evidence that you believe, because it outweighs, in your mind, the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. You must weigh the quality of the evidence. Quality may or may not be identical with quantity or the greater number of witnesses. In deciding whether an issue has been proved by a preponderance of the evidence, you should consider all of the evidence regardless of who produced it. If the weight of the evidence is equally balanced, the party who has the burden of proof has not established such issue by a preponderance of the evidence. Evidence is all the testimony received from the witnesses and the exhibits admitted during the trial. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the party who has the burden of proof has met that burden. Direct evidence is the testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes exhibits admitted into evidence during the trial and stipulations that you were instructed to accept as fact. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically follow according to the common experience of people. To infer or to make an inference is to reach a reasonable conclusion of fact that you may, but are not required to, make from other facts that you find have been established by direct evidence. You may infer a fact or reach a reasonable conclusion about a fact only from other facts or circumstances that have been proved by the greater weight of the evidence. Whether an inference is made rests entirely with you. The court has admitted exhibits concerning certain evidence. These will be with you during your deliberations. You will determine what weight, if any, the exhibits should receive in the light of all the evidence. The evidence does not include the pleadings, those are the court filings, or any statement of counsel made during the trial, unless such statement is an admission or agreement or stipulation admitting certain facts. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers ordered stricken or to which the court sustained an objection or that you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not guess why the court sustained the objection, any question, what the answer to that question might have been. You must not consider as evidence any suggestion included in a question that was not answered. You may have heard comments during opening statements by the lawyers addressing how the workers' compensation system works and whom it impacts financially. Those statements are not evidence and cannot be a factor in your deliberations. Nothing about the system, how it works, or the finances of the same can be a factor in your deliberations or your decision. You are the judges of the facts, the credibility or believability of the witnesses, and the weight of the evidence. To weigh or determine the greater weight of the evidence, you must consider the credibility or believability of the witnesses. You will use the tests of truthfulness that you use in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, and the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You're not required to believe the testimony of any witness simply because the witness was under oath. They all were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Some testimony was presented by video deposition. You are to consider this evidence according to the same test that you apply to other testimony, and consider the testimony the same as if the witness appeared live in the courtroom during the trial. Normally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions may have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based upon that assumption. You must decide whether the assumed facts on which the expert based his opinion are true. If any assumed fact was not established by the greater weight of the evidence, you will decide the effect of that failure on the value of the opinion of the expert. Questions may have been asked of the expert witness after he had disclosed the underlying facts or data. It is for you, the jury, to decide if such facts or data on which he based his opinions are true, and you will decide what weight to give such evidence. As with other witnesses, on you alone rests the duty of deciding what weight to give to the testimony of the expert. In deciding its weight, consider his skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility or believability and deciding the weight to give to the testimony. Do not let bias, prejudice, or sympathy play any part in your deliberations. A corporation or governmental entity and all other persons are equal before the law and must be treated as equals in a court of justice. The Workers' Compensation Law of Ohio provides that employees who contract occupational diseases in the course of and arising out of their employment are entitled to participate in the Workers' Compensation Fund. In this case, the parties agreed that plaintiff Timothy J. Murphy was an employee of City of Painesville. Plaintiff is seeking to participate in the Workers' Compensation Fund for the condition of bilateral carpal tunnel syndrome. The defendant specifically denies that this condition is a direct and proximate result of his workplace. The issue you must decide is whether or not Timothy J. Murphy is entitled to participate in the Workers' Compensation Fund for the condition of bilateral carpal tunnel syndrome. The disputed issues for your decision are: 1. Did Timothy J. Murphy develop bilateral carpal tunnel syndrome? 2. Did Timothy J. Murphy develop bilateral carpal tunnel syndrome in the course of his employment? 3. Did the occupational disease of bilateral carpal tunnel syndrome that Timothy J. Murphy developed arise out of his employment? Timothy J. Murphy must prove that the conditions of his employment resulted in a hazard which distinguishes his employment in character from employment generally, and that his employment at City of Painesville created a risk of contracting bilateral carpal tunnel syndrome in a greater degree and in a different manner than the public generally, and that he acquired bilateral carpal tunnel syndrome as a proximate result of exposure to his work environment or the physical conditions of his job. An employee is in the course of employment while performing the obligations of his service or job to be performed for the employer. An employee is in the course of employment when performing some required duty done directly or incidentally in the service of the employer. An occupational disease arises out of employment when proximately caused by something that occurred as part of the activities, conditions, and risks of the workplace. The law requires that Timothy Murphy must prove that an injury or disease was suffered in the course of his employment at City of Painesville. An employee is in the course of employment while performing the obligations of his service or job to be performed for the employer. An employee is in the course of employment when performing some required duty done directly or incidentally in the service of the employer. The phrase "in the course of" relates to the time, place, and circumstances of the injury suffered. Participate in the Workers' Compensation Fund means to be entitled to receive benefits from it. Benefits may include payment for medical treatment and/or compensation to the employee. Proximate cause is something which, in the natural and continuous sequence, produces an occupational disease, and without which the result would not have occurred. An occupational disease was caused if it was produced in the natural and continuous sequence by something that occurred as part of the activities, conditions, and risks of the workplace. There may be more than one proximate cause of an injury when workplace activities, conditions, and risks combine with other causes to proximately produce the injury. Each is a proximate cause. It is not necessary that each cause occur at the same time or place. Injury does not include any injury or disability caused primarily by the natural deterioration of tissue and organ or part of the body. Employers take their workers as they find them and assume the risk of having a weakened condition aggravated by some occupational disease, which might not hurt or bother a perfectly normal, healthy person. If that occupational disease is the proximate cause of the condition for which compensation is sought, the previous physical condition is unimportant, and recovery may be had independently of the pre-existing weakness or disease. There was discussion about activities of the agency administering the Workers' Compensation Fund. You must ignore such discussion and determine this case solely upon the evidence presented to you in this court. The issue you must decide is whether Timothy Murphy is entitled to participate in the Workers' Compensation Fund for the condition of bilateral carpal tunnel syndrome. If you find that Timothy Murphy is entitled to participate, you will not consider any amount of compensation because that is determined by the Industrial Commission. If you find that Timothy Murphy has proven by the greater weight of the evidence all of the elements of his case, then your verdict must be that he is entitled to participate in the Workers' Compensation Fund. If you find that Timothy J. Murphy has failed to prove by the greater weight of the evidence any element of his case, or if you find that the evidence is evenly balanced on any element, then your verdict must be that he is not entitled to participate in the Workers' Compensation Fund. The court has given you the instructions on the law applicable to this case. I will now instruct you on how to conduct your deliberations and prepare your verdict. So I'm going to switch to the verdict form, and it's one page. It identifies the parties at the top, and the body of it says, "We, the jury, find that Timothy J. Murphy," and then there's a blank line. Underneath, it says, "Insert in ink, is or is not entitled to participate in the Workers' Compensation Fund for the condition bilateral carpal tunnel syndrome as having occurred while in the course and arising out of his employment with the City of Painesville, at least 6 of us so agreeing as indicated by our signatures below." I have signature lines for all of you. Whatever your verdict is, 6, 7, or 8 of you have to agree with that. The verdict does not have to be unanimous. A 3/4 verdict is the law on civil matters in the state of Ohio. So 3/4 of the 8 would be 6. So 6, 7, or 8 will have to sign and agree on whatever your decision is or is not entitled to participate. So, Tony, if you get the lights. The attorneys will argue the case. Mr. Kuzma will go first. He does have the burden of proof, followed by Ms. Nimrick, and then Mr. Kuzma will rejoin because he does have the burden.
Thank you, Judge. Good afternoon, everybody. Just like to start by saying thank you again for your patience and time during this trial. I would also like to thank the court for their time and resources, and Attorney Nimrick as well. I'd like to thank you for your time and professionalism throughout the whole process. After hearing all the evidence presented to you in this short but concise trial, I believe we have met our burden to show that Mr. Murphy, 1, has carpal tunnel syndrome, bilateral, and 2, that it's as a direct response to his employment with the city of Painesville. You heard Mr. Murphy testify extensively about his physical aspects of his job over the past 31 years before his retirement. I know it wasn't the most engaging testimony. He was on the stand a long time. I was present. I know it wasn't the most engaging, but it was very important to hear all the details about all the physical jobs that he did. Essentially, it was the crux of the case. He talked about having not your typical job of 8 hours of typing, your typical carpal tunnel syndrome scenario. The perfect scenario is just to point to and say, carpal tunnel, 100% is from that. Instead, he had a job, as most people do, that's not typical. He had a physical job with the city for over 3 decades, where he worked physically with his hands. He did many, many jobs throughout the city, as he testified to, which any one of them could cause carpal tunnel. He worked with power tools, he worked with hand tools, he worked with machinery. He used a chainsaw, he testified, sometimes for 8 hours a day as needed. He used hand tampering extensively year-round. Technically his main job throughout the city. He used hand drills and other vibrating tools as needed. Jackhammers for hours, and that's going to be important later. Jackhammers for hours, depending on the need. Sometimes for weeks at a time, for multiple hours a day, including 6 to 8 hours a day. He used some gas tampering machinery, which was vibrating with both hands. As I said before, he used a lot of hand tampering, which was physical trauma to his hands as he's pounding down on the asphalt in order to level it out for the streets. He testified to the different lawn care machinery, the lawnmowers, the weed whacking, all vibrating tools in and of themselves. He testified to using sledgehammers and presses in order to pound fence posts in, and then using his hands with hand tools, pliers to twist to twist the wires in order to put up fences. 31 years of the same job, the same duties. There's no change. There's no time limits ever put on the type of jobs that he would do. It was 31 years of physical work for the city of Painesville. The one person that testified in this whole matter to any kind of rotational work program was Dr. Trangle. And I like to talk about Dr. Trangle for a little bit. I know we just saw his deposition, his testimony. I had a lot of issues with it, but I think some of it does highlight our arguments and actually helps our case out. He's the one who does not take in consideration all the tools and all the machinery that Mr. Murphy used during his time. I found him very defensive in answering a lot of questions, but more importantly, I don't believe he has a complete report and a complete testimony in this case. Dr. Trangle, as Attorney Nimrick stated herself, was hired by the BWC to review this case and render his opinion in a report and ultimately testify at trial. This was done in April of 2022. Mr. Murphy has an EMG, a positive EMG for bilateral carpal tunnel from 2015. Dr. Trangle is already at a disadvantage of examining Mr. Murphy, going over his file review, going over his files from years prior. He did not examine Mr. Murphy until April of this year, meaning he's already had years of retirement. He's also had years, as Mr. Murphy testified, years of injections directly into his wrist, not just the initial one in his thumb, over about a dozen injections into his wrist for specifically carpal tunnel after starting to see Dr. Weinsberg in 2019. While Dr. Trangle may be a medical doctor, I will take Dr. Wyrick and a treating physician for a client 100% of the time in this case because of his knowledge with Mr. Murphy, his personal experience with Mr. Murphy, and the knowledge of Mr. Murphy's, all of his injuries, all of his medical conditions, his work history. And one of the main reasons I would take Dr. Wyrick for all of those reasons is Mr. Murphy was on the stand for over 2 hours yesterday. You know more about this case. You know Mr. Murphy more than Dr. Trangle does. He spent less than 2 hours with him. He said Percy said maybe 2 hours, maybe an hour and a half. He didn't write it down. You heard Mr. Murphy speak about his physical conditions, his work duties at the city more than Dr. Trangle has. You know more about the case than Dr. Triangle does. And again, this was the only time Dr. Triangle examined and talked to Mr. Murphy was after a series of injections, after years of retirement from the city. He didn't list in his report, although he said he took them into consideration, he didn't list in his report a lot of the tools that Mr. Murphy testified to, and you'll have in the exhibits, not just anything that we talked about in terms of the exhibits that the doctors had, you'll have that job description as well. If the city of Painesville had a rotational work program, it would be in there. There would be evidence of it. Mr. Murphy testified yesterday very strategically in a question that I wanted to make sure was proper. He was never told by any supervisors, management, overhead, that you can only do chainsaws for a day, and then you have to do something else. Regardless of the reason they gave him, he was never given a time limit. It was, this is what was needed to be done. You are going to do it until it's done, and he did it. For 31 years, he did it. Additionally, Dr. Triangle's argument, I think, is just completely inaccurate and flat out wrong, since there is no support at all about a rotational work program. I think, given the facts of this case, the job description that Mr. Murphy testified to, that you'll have an exhibit up to go over in generalized detail, the treatment notes, you will see that Mr. Murphy was exposed to his physical work nonstop for 31 years. Furthermore, in regards to Dr. Triangle, he does agree that Dr. Triangle and Dr. Wyrick both agree that Mr. Murphy does not have any of the high risk factors for carpal tunnel that people normally have or that you normally see. The only risk that he has is his job. He doesn't have any other hobbies that he testified to. He doesn't have any other specific trauma to his hands or wrist prior to 2015. He does not have rheumatoid arthritis. He doesn't have diabetes. Both doctors agree with that. The only other medical condition he has besides the neck that we talked about, the lumbar back issues, the bilateral knee issues after a pretty severe injury, is his blood disorder. That has no bearings on carpal tunnel. That's not the same thing as an autoimmune disease. That's not rheumatoid arthritis. So he does not have any of those risk factors. Both doctors agree to that. And I will say, if that was the case, because as I pointed out to Dr. Triangle on cross-examination, that Dr. Triangle wrote in his report that Mr. Murphy has other medical conditions. Yes, he does. But if you're going to use that to say that carpal tunnel is not there, you have to be more specific. There's nothing there to say that other medical conditions cause this carpal tunnel, or again, the burden's on us. If he's saying there's other medical conditions, it looks like more likely than not it's caused by those. I guarantee that would be his main argument, and that is not what he said. I pushed him to explain any other medical conditions, and he did not state anything besides generally he has medical or other conditions. Importantly, there's other inconsistencies with Dr. Triangle's testimony. Pretty early on, he said, in trying to explain how people normally get carpal tunnel, he said himself, well, you can get it, some people get it from jackhammering 8 hours a day, months after months. That is what Mr. Murphy testified to yesterday. The only difference is, it wasn't just months after months, it was 31 years of that. And after jackhammering, chainsawing, all the mechanical tools, the power tools, not months after months, years after years, decades after decades in this case. Importantly, too, Dr. Triangle, which I kind of have to thank him for it because I think it helps the jury, hopefully it helps you understand, I know it helped me understand what doctors look for in general, whether it's Dr. Wyrick, Dr. Triangle, what they look for in order to diagnose carpal tunnel syndrome. He said there's 3 things, then he changed it to 4, but it made sense the way he described it. He looks for symptoms, he looks for clinical findings, he looks for an EMG, and he looks for the job history. Well, let's start with the 3 things, the symptoms. He listed them, pain, falling asleep, paresthesia in the hands, keeping them up at night. First he said there was nothing in those records. I went one after one in some of those records and he pointed out, yes, it was there. Yes, Dr. Wyrick noted that he had fatigue in his hands. Yes, Dr. Weisberger, granted it was in 2019, noted that he had to switch hands because of fatigue and it was keeping him up at night. The symptoms were there. You heard Mr. Murphy testify to his symptoms. He had those symptoms for a long time and they developed and got worse as time went on. So I don't think the symptoms is that good of an argument to say that they weren't present. But more importantly, Dr. Trangle focused on clinical findings, the examinations, the hand test, the Tinel's test, the Finkelstein test, the Fennell's test. He said they're not present. When pushed on that, Dr. Weirich, in his report, had those specifically. What was Dr. Trangle's response when I had him read those? Even though he should have been aware of them when he wrote his report, he stated, I just don't believe them. So I asked him, is it because you think they were inaccurate? He couldn't answer that. Even assuming he doesn't believe Dr. Weirich for some reason, then I had him read on Dr. Weisberger, Dr. Weinberger, the doctor from June 2015, who then conducted the EMG on Mr. Murphy. He had positive findings for those same tests, the same type of clinical test that people use to diagnose carpal tunnel. And even after that, the third part, the EMG, Dr. Trangle, which Dr. Weirich calls the gold standard, which even before this trial, I believe that was the gold standard. You get an EMG, you get an MRI, those are the highest diagnostic tests that you want to confirm anything. Even with the EMG specifically saying mild bilateral carpal tunnel, he still did not want to believe that. In fact, he talked then, he tried to redirect it about having the neck issues. Yes, I completely agree, because as the timeline showed, Mr. Murphy has a neck issue. That was probably what delayed the carpal tunnel for a while as well in terms of finding the diagnosis, because he was having radiating pain. His EMG was to find out what the issue was. That EMG not only confirmed carpal tunnel, specifically, and you'll have it in there, you'll have it in the exhibits, the EMG specifically denies radiculopathy, radiating pain from the neck, meaning those hand issues, those wrist issues that Mr. Murphy was complaining and told Dr. Weirich about. Dr. Weirich told him, you need to see a specialist. He saw a specialist, Dr. Weinberger. Weinberger said, hey, you need to get an EMG. Those hand issues are from carpal tunnel. It wasn't a combination. We would be having a different argument, different conversation. This is specifically from carpal tunnel per that EMG. And then the fourth thing, obviously the big thing here, is the work history and what kind of activities you do. I'm not going to go into all those again because it's the same thing, the power tools, the hand tools, the years of physical work. So Dr. Trangle, again, I don't believe he had completely accurate, I wouldn't say accurate, but I don't think he was fully taking everything in consideration. He was not aware of Dr. Weisberger's medical records till the day of his deposition. He was not aware at the time, even when he examined Mr. Murphy in April of this year, that Mr. Murphy not only had that right thumb injection, that he's had a series of injections in his hands, like I said before. I think that would be important to put in your note. If someone is actively treating for carpal tunnel syndrome, and you're examining them and giving them a full review and reviewing the records and giving your opinion, you would put in your record whether or not they're actively treating for it. Granted, Mr. Murphy, unfortunately, as he said, his last injection was November 2021. This examination with Dr. Trangle, April 2022. Fortunately, he had to stop the cortisone because it was giving him vision issues. But still, he was treating for carpal tunnel. I think that would be a big thing for Dr. Trangle to write when he's supposed to be doing a full review. I would argue Dr. Trangle saying that he doesn't even think carpal tunnel is there. Granted, this is not a legal argument. This is not, I'll say this is an opinion right here. It seemed to me, per his testimony, that he kind of stopped. And when I asked him, do you talk to your patients and clients? Do you ask them about their job hobbies? Their hobbies outside of the job? Do you talk to them about anything besides what the records show? And he essentially said he kind of stopped because he doesn't think Mr. Murphy has carpal tunnel. So I asked him, in any other case, would you ask details? And he said yes. In this case, he did not. So, in my opinion, if you believe Dr. Weirich, if you believe Mr. Murphy's job experience and his history of work, and you believe he has carpal tunnel, which I think is clear as day given the factors we just went over, I think Dr. Triangle's opinion stopped short of actually giving a full opinion on whether or not he thinks Mr. Murphy's carpal tunnel is from his work from his work with the city. He essentially stopped short. Just going back to timing the carpal tunnel, like I said, I know it's complicated. Most cases that go to trial are. Mr. Murphy having other issues, especially with the neck injury, the bilateral knee injury, it does throw a wrench in terms of it's not a clear-cut case. You have carpal tunnel issues, you go and get an EMG, and many other medical issues. I think the main point to take away from that is, one, he had issues for years. He had other unrelated issues and injuries. He continued to work. He was getting treatment for priority and what was bothering him the most. When he was off of work for those 7 months for his terrible knee injury, the steel plate falling on him, those 7 months, the way I look at it, his carpal tunnel did not get any worse, did not get any better. And that tells me two things. One, he already had it. And two, there was nothing that he was doing outside of work that was causing it. If he was not working for 7 months and his carpal tunnel was getting worse because he was at home, he had more time, granted he was pretty bedridden because of his knees, if he had any hobbies that would bother his carpal tunnel in his hands and wrists, I can't say for sure, but I would say that it would probably make his hands and wrists worse at that time since he's not working. One of the big issues too is why did he wait to get treatment? Obviously, I have to talk about the positives of the case and the negative. Waiting for treatment, again, his other injuries did take priority. Two, following his treatment with Dr. Wyrick, where he talked to him, set up the consultation, he was essentially told off the bat, you need to go see a specialist, and we know, even in layman's terms, not being medical experts, carpal tunnel, there's not a lot you can do for it. There's some treatment, but it's pretty much injections or surgery, the carpal release surgery. That wasn't testified to the surgery too much, but at this point, remember, Mr. Murphy testified he knew about his blood disorder from about 2010 or 2012 at the latest. He knew that he was unable, because of his other injuries, this is how he found out, he's not able to get surgeries. Injections, he ended up trying in 2019, we saw how that happened. So there was a gap in treatment, or there was a wait in terms of getting any treatment. But the only other, I think the bigger factor too is, besides his other injuries that took priority, is, as Dr. Wyrick testified, this claim has been filed since 2016. The EMG was from a year prior to that. We are just going to trial now. It is October 2022. Workers' compensation, without getting into it, as the judge instructed us to, there's a different process prior to trial. It's not a speedy process. So I don't think it's fair to completely completely fault my client, Mr. Murphy, for waiting a certain amount of time before actually getting treatment. His case has been pending for a while. You're hearing it now. This is what we're deciding, whether or not the carpal tunnel should be a recognized claim, recognized workers' compensation claim. That's the whole point of this trial. I talked about the blood disorder. And to be honest, to be frank, the treatment I don't think really matters too much in this case, because you aren't deciding treatment. You aren't deciding whether or not treatment should be rendered or if it should be approved. You're just deciding whether or not he has carpal tunnel. So regardless if he has carpal tunnel and you say, yeah, he had carpal tunnel from 2015 or 2016 when the claim was filed, that's it. That's all you're deciding. If you think he has carpal tunnel from work, any period between now and going back to when the claim is filed, we have proven our point. That's the only burden that we have to prove. I asked you at the beginning, I kept a short opening, but I asked you to take a look at all the evidence after presented, reflect on it when you deliberate, and ask yourself what makes the most sense in this case. Is it more likely than not Mr. Murphy has bilateral carpal tunnel syndrome? I would say yes. Is it more likely than not that he has it because of his work with the city? I would say yes. We have the positive symptoms, we have the clinical exams, we have the EMG, despite Dr. Triangle not wanting to admit that those are present. On cross, he did, but still did not change his opinion. Is it more likely than not it's from the city? Again, over 3 decades of work. physical trauma to his hands, repeated trauma. The one last thing I'll say about Dr. Triangle, too, is at one point he testified to the tampering. I asked him if he knew what a tamperer was. And he said yes, he generally knew. He said he wasn't familiar with what the city used. If they used a gas one, I asked him about an electric one, a hand one. He doesn't know. But yet he thinks he knows the rotational work program of the city somehow. But he doesn't know the tampering specifics. Mr. Murphy's testimony, from what I gather from it, asphalt and concrete, but asphalt specifically, that was his biggest job at the city. That's what he specialized in. That's what he did before he was hired. He was hired directly as a maintenance worker one, specifically for asphalt. So for Dr. Triangle to not know the specifics of the tampering, I think is a big red flag in terms of his opinion. But I also think it goes to show Mr. Murphy, his extensive use of the tampering and his asphalt work, in addition to everything else, really shows the type of physical work he did for the city. I don't believe anyone would argue whether or not Mr. Murphy was a hard worker. He sacrificed his body for the city for over 3 decades. Multiple injuries. He's a beat-up man. He's nice, but he's beat up. He testified yesterday that he had to retire early due to his injuries, and he wished that he didn't, and if he didn't retire because of his work injuries, he'd still be working to this day. We don't have to get into specifics of if it's mostly his knees, his hands, his neck, his back. It's a culmination of everything. After his knee injury in 2014, he was off work for 7 months, so a little over 6 months. You heard him testify, it's in the records too, that he was worried about going back, but he still did it because he was a hard worker. I do believe that the evidence points to his hands and wrists being a part of the reason why he had to retire. And it's everything we laid out for you. It's the doctor's depositions, it's testimony, the exhibits, Mr. Murphy's extensive testimony yesterday. And I'll leave you with this, besides any short rebuttal that I might have, is Dr. Triangle said in his deposition that in 50% of cases we don't know where carpal tunnel comes from. Great. This is the other 50% where we know. I think the evidence is overwhelming. At the very least, tips the scale in our favor, but this is the 50% of cases that we know where it's from and where we can point to. Thank you again.
And Ms. Nimmer?
Thank you, Your Honor. First of all, I'd just like to echo Mr. Kuzma's thanks to all of you for being a part of our trial, for being here to assist us in rendering a verdict in this case, and also to the court and everyone who helped us put this together, and to Mr. Kuzma and Mr. Murphy for being so professional and a pleasure to deal with in trying this case. Dr. Wyrick said something very important in response to a question Mr. Kuzma asked him about whether Mr. Murphy had told him about something. He said, had he conveyed that, it would be in my notes. He later told me that he would include in his notes the pertinent stuff. Now, it was kind of hard to question him about his notes because he didn't have them with him when he testified. But you will have them with you when you go back to deliberate. That binder is Joint Exhibits 1 through 6, and Dr. Wyrick's records are the bulk of that. They're Joint Exhibit 5. And I would encourage you to go through those, and you'll have them, Mr. Kuzma and I put them in chronological order, so you can flip through and see the entirety of his treatment with Mr. Murphy and what Mr. Murphy was complaining of when he saw Dr. Wyrick. Doctors speak through their records. That's how they record the patient's history, their medical background, their complaints, their symptoms, the course of their treatment. Doctors don't expect themselves to remember things from one visit to the next. They put things in their records. And what's not in those records is every bit as important as what is. Let's look at the timeline in this case. First of all, we've seen no medical treatment or reports of any problems with Mr. Murphy's wrists prior to 2015. Now, he testified that he had some symptoms that would come and go over the years ever since the 1990s. that he would come home from work after a tough day, maybe feel some numbness and tingling, shake out his hands, and that would resolve. But there's no medical evidence that he ever mentioned that to his treating doctors. And he had a lot of treating doctors over the years for a lot of different problems. He was never without a doctor that he could have reported those problems to. In November of 2014, we know Mr. Murphy had a very serious injury to his legs when a steel plate fell on his knees. He had significant knee injuries. He developed pulmonary embolisms. He told us he went into renal failure. He almost died. It was a very serious injury that kept him off work for 7 months and fairly immobilized for the first several of those months. He couldn't drive, couldn't walk. He was taking it easy. He started seeing Dr. Wyrick on January 6th of 2015 related to that 2014 injury, but couldn't really start therapy even for a couple of months after that. And we'll see in those notes from Dr. Wyrick from January 6th of 2015 until he went back to work, there's no mention of anything regarding the wrists or hands. There's a note on May 7th of 2015 from Dr. Wyrick regarding complaints of facial numbness and shortness of breath. And those concerned him and led him to refer Mr. Murphy to see Dr. Weinberger, who was a neurologist. But there was no mention in those records that he was complaining of anything with regard to his wrists. On June 3rd, Mr. Murphy came back to see Dr. Wyrick and mentioned that he was returning to work on light duty the next day and that he was anxious about returning because of the ongoing problems he was having with his legs. Well, on that same date, June 3rd, 2015, he had that neurological consult with Dr. Weinberger that Dr. Wyrick had set him up with. And you will have Dr. Weinberger's records. That's Joint Exhibit 2, and I would encourage you to look at those too. Dr. Weinberger noted that Mr. Murphy had a history of neck problems and that he had had recent pain and numbness for several weeks with numbness down his arms into his hands. This is the first time in the medical records there's any mention of any symptoms regarding his wrists or hands. Dr. Weinberger ordered an EMG to check for radiculitis or neuropathy. He was mostly concerned there might be something going on with his history of neck problems. And he did an examination on that day and found that Mr. Murphy's muscle strength in his upper extremities was normal. His sensory exam was normal. These are important because Dr. Trangle told you in making a diagnosis of carpal tunnel syndrome, those are some of the clinical tests you have to look at to see whether there's actually carpal tunnel present. Those findings were not there when Dr. Weinberger saw him on June 3rd. So on June 4th of 2015, Mr. Murphy returned to work after 7 months off for that 2014 injury. And he returned on light duty and was assigned to ride the lawnmower to mow the cemetery. He continued treating with Dr. Wyrick throughout this time about 1 to 2 times a week. You'll see all those notes, including after he returned to work. And you'll see that there's no mention in any of those notes of any problems he was having with his wrists. There's lots of leg complaints and fatigue that he was having from his return to work, from mowing and then later flagging. On July 2nd, 2015, Dr. Weinberger, the EMG was done that Dr. Weinberger had ordered. And you'll have a report of that. It's Joint Exhibit 3. And that report indicated it was consistent with mild bilateral carpal tunnel syndrome. And Dr. Weinberger, as a result of this, recommended that Mr. Murphy follow up with a hand specialist. There's no mention anywhere in that report of his employment or of any relationship to his employment. There was no follow-up after that with any specialist or with any other doctor. And there were no further visits anywhere with Dr. Weinberger. But Dr. Trangle told you that the finding of being consistent with mild bilateral carpal tunnel syndrome isn't necessarily sufficient for a firm diagnosis. And he mentioned there's 3 things you have to look at. You have to look at whether there's a consistent pattern of ongoing symptoms, and we've seen the records around this time, there was no consistent reports of ongoing symptoms. You have to look at clinical findings and test results on examination. And the only exam that was done around that time was by Dr. Weinberger on June 3rd that only found normal strength, normal sensation. None of the other clinical tests that Dr. Trangle mentioned were done at all until almost a year later when Dr. Wyrick did them. And he mentioned that then the EMG is another factor you look at. But there was no clinical correlation in this case, which is why Dr. Trangle is skeptical of the overall diagnosis of carpal tunnel syndrome. You will see from Dr. Wyrick's records that Mr. Murphy continued ongoing regular treatment with Dr. Wyrick for the rest of that year of 2015. And again, there's no mention in those records regarding problems with his wrists. He retired at the end of 2015 with public retirement through the Public Employee Retirement System after a 31-year career with the city of Painesville. But he continued treating with Dr. Wyrick because he was still having these problems with his legs and his other issues. You'll see that there's no mention of any wrist issues in Dr. Wyrick's notes until his visit on May 18th of 2016. That was 10 months after the EMG had been performed, and it was 4.5 months after he retired when he was no longer working. At that point, Mr. Murphy reported that he was having wrist problems that he dated back to mowing when he first returned to work 10 months earlier. And Dr. Wyrick noted in that report on May 18th, onset of his symptoms occurred through a consecutive date time frame in June 15 while he was operating riding mower. He noted that his symptoms worsened to the extent that he felt medical intervention was necessary, and he underwent electrodiagnostic testing with Dr. Weinberger on July 2nd, 2015. Now, that statement is not consistent with the real timeline that we've just established here. So suffice it to say, things are being adjusted a year later. They're trying to fit this into a workers' compensation claim that got filed on that day for the first time, May 18th, 2016. And you'll see Mr. Murphy's first report of injury, his application for workers' compensation benefits, that's dated May 18th of 2016. And that also is in exhibits as Exhibit 1. Now, I mentioned that when Dr. Weinberger did the EMG, he suggested a follow-up with a hand specialist, and Mr. Murphy didn't do that. In fact, he didn't follow up with a specialist until 4 years later when he saw Dr. Weisberger in 2019, and you'll see his report, which is Joint Exhibit 6. And that's significant because a lot can change over 4 years. And to have anything from then and try to relate it back to his work that he hadn't done in 4 years at that point is pretty impossible. Now it's interesting, we also have here kind of a shifting theory of causation because when Mr. Murphy filled out his first report of injury, he really emphasized these problems developing after he returned to work as a result of the riding lawnmower. And that's what Dr. Wyrick put initially in his report on May 18, 2016. But then it sort of morphed more and more into this. Well, no, it's really from just the overall 31 years of work experience. And I think that's partly because there was this visit before he ever went back to work with Dr. Weinberger. So clearly it wasn't the mowing that caused this condition. Now, the one thing I absolutely agree with Mr. Kuzma on is that there is no question Mr. Murphy was an incredibly hard worker and that he did a physically demanding job for 31 years. He said the city had recognized him as being a hard worker. He performed a public service for 31 years. Nobody disputes that. But it's not physical work that puts one at high risk for carpal tunnel syndrome. It's highly repetitive work. And that's a very specific category of work. And Dr. Trangle gave you an explanation of what highly repetitive work means in a medical context. And what it's talking about is doing the same motion over and over and over all day, every week, every month. So usually people on assembly lines who are doing a particular task repeatedly, and that's all they're doing. That's why you see it in people who do nothing but type all the time. And Dr. Trangle emphasized that what's important in this case is that Mr. Murphy did a wide variety of work duties. And we heard about those extensively. And he did not do one task over and over. He did not just jackhammer, for instance. And Dr. Trangle, as an occupational medicine specialist, said he counsels employers about how to create safer workspaces. And one of the things he says they should do is have a job description like Mr. Murphy's, where people do a lot of different things. And Mr. Kuzma emphasized a lot this rotational concept. But we're not talking about some formalized, Dr. Trangle never says it's like a formalized, you do this for this amount of time and that for that amount of time. He said what it's talking about is where you're moving around and doing a lot of different tasks, so you're not doing the same thing for your entire career. So a city, for example, would not hire somebody to be the jackhammer operator where that's all they're doing, and that could cause a problem. And Dr. Trangle also told you that half of all carpal tunnel cases do not have a specific cause at all, and that it's especially common with people as they age. That's for a variety of biological reasons that can vary from person to person. So we don't just default to, well, we don't have anything else, so it must be his employment, and fit it into that. And another thing that's significant is the fact that Mr. Murphy says his symptoms did not get better at all, even when he was off work for those 7 months, or even after he retired for all the years since he's been retired, supports the conclusion that his work was not the cause. As Dr. Trangle told you, if the work was the aggravating factor that was causing these symptoms, then when he's no longer doing that, they should get somewhat better, even if he has diagnosable carpal tunnel syndrome. There would be some relief from being off work. Now, keep in mind that the only doctor who testified here that Mr. Murphy's carpal tunnel syndrome is work-related is the chiropractor, Dr. Wyrick. He's not a medical doctor. He can't prescribe medications, he can't give injections, he can't perform surgery, he can't admit patients to hospitals. His scope is much more limited than a medical doctor's would be. But it's interesting that Dr. Weinberger's not here telling you this is work-related. He didn't say that anywhere in his record. Dr. Weisberger's not here telling you this is work-related. And you'll see his records. And he treated Mr. Murphy in 2019. Mr. Kuzma was critical of Dr. Trangle for making a determination about whether or not Mr. Murphy has carpal tunnel syndrome years later because he didn't see him in 2022. And obviously that's a factor that Dr. Trangle said Mr. Murphy didn't have these same complaints or findings when he saw him in 2022. But the plaintiff's entire case is based on opinion that Dr. Wyrick made a year later. So we already had that gap. Even though he was treating him that whole time, there was never a firm diagnosis or a causal relationship opinion given until a year afterwards. So I believe once you've gone through all of the evidence, and particularly gone through all of the medical records, which were made contemporaneously with that treatment, the evidence will not be sufficient to establish that Timothy Murphy contracted bilateral carpal tunnel syndrome as an occupational disease as a result of his employment with the city of Painesville. And I would request that you return a verdict that Mr. Murphy is not entitled to participate in the workers' compensation fund for that condition. Thank you very much.
Ms. Kuzma, rebuttal.
Thank you. And I'll be very short, just to address a few of the main points. Attorney Nimrick mentioned Dr. Weinberger in June of 2015, that Dr. Wyrick referred Mr. Murphy to Dr. Weinberger for issues relating to possibly he was having face numbness and lip numbness. But he also was having, as he testified, concerns about his hands and wrists. So he, as a chiropractor, as the treating physician for Mr. Murphy for all of his injuries, referred him to a specialist to see what was going on. After the EMG, Dr. Weinberger noted carpal tunnel symptoms and the positive EMG. And the EMG. And specifically in his report and his treatment notes, told Mr. Murphy he should go see a specialist. So he's not a testifying physician, but in his notes it's very clear he felt Mr. Murphy had carpal tunnel based on the diagnostic testing and the complaints that Mr. Murphy specifically told the doctor. Attorney Nimrick mentioned Dr. Wyrick and his treatment notes. You'll have access to all these treatment notes. This is from 2014. This is mainly from his bilateral knee injury. The reason why we don't have treatment notes for this specific carpal tunnel claim is because it's not a claim yet. Until you can go and deliberate and decide, hopefully, that it should be a recognized claim, there's no treatment notes to put in as exhibits. Any treatment notes besides the new injections that Mr. Murphy testified to about, that's Dr. Wyrick's report that he testified to. You don't have that because he testified to it, just as Dr. Tranquil. You have Dr. Weinberger, Dr. Weisberger. And importantly, too, the timing of the claim, you have the first report of injury. So any argument about this shift in causation, I think, is completely false. You'll have the first report of injury that was filed by Dr. Wyrick and Mr. Murphy in May of 2016. And he specifically states, we haven't read it, but you'll have it, that he does talk about his years of work with the city, and that's what he pinpoints it to. As Dr. Wyrick summed it up in a very funny saying, it's the straw that broke the camel's back. After being off of work for 7 months for an unrelated injury, he returned back to work, importantly on modified duty to protect his knees after the steel plate. The modified duty was not designed to protect his hands, his wrists in any way. So he was mowing, he was flagging, he testified to that it was only after that, because again, the carpal tunnel symptoms were about the same for a month after he was on that modified duty. But after a month of lawn mowing, after a month of standing there and flagging for 8 hours a day, that's when his carpal tunnel flared up. But as I said before, he already had carpal tunnel at this point. It was symptoms that would come and go. This is the straw that broke the camel's back. Again, he was referred for the EMG, but regardless of why he was referred to the EMG was positive for bilateral carpal tunnel. So, good thing it was ruled out for his neck, because the reason why they were so concerned and focusing on that is because he already had an established neck injury, a severe one, with herniations and stenosis and radiating pain previously. So they wanted to rule that out. So it's a good thing they ruled that out. Unfortunately, it was not negative for bilateral carpal tunnel. The last thing I'll address, Dr. Wyrick is a chiropractor. I said that from the beginning, we're not hiding it. The real reason, if you want to get down to it, why he's testifying as opposed to a medical doctor is because he's Mr. Murphy's treating physician. He knows him better than any other doctor. Unlike the Bureau, who went and found a doctor to do, I keep saying IME, and I know I said it in the deposition, independent medical examination, where they find a doctor, you pay them, they do a review, they testify as needed after a report. That's not what Dr. Wyrick is about. He's a treating physician. He wanted to testify on Mr. Murphy's behalf, and he did. So instead of finding a medical doctor to sum up what Dr. Wyrick would testify to and pay a medical doctor to do that, we had the treating physician take everything in consideration and present it to you because he's Mr. Murphy's treating physician. That's the big difference. You have what I feel is the medical doctor's support, the evidence, Dr. Weinberger, Dr. Weisberger, and more importantly, you had the whole testimony from Mr. Murphy and Dr. Wyrick. Thank you again. Appreciate it.
Tony, the lights. The court has given you the instructions on the law applicable to this case. I will now instruct you on how to conduct your deliberations and prepare your verdict. When you go to the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than others. The foreperson serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict form and any exhibits are returned to the court after you've reached a verdict. In order to conclude this case, it is necessary that at least 6 members of the jury agree upon the verdict. The members of the jury agreeing upon the verdict must sign their names in ink to the agreed-upon verdict form. You are warned not to discuss the status of your deliberations with anyone outside of the jury room, nor are you to discuss your verdict with anyone other than your fellow jurors until it has been returned to the court. When you have reached and signed a verdict, you will summon the bailiff, who will return you to the courtroom, at which time your verdict will be announced. The court cannot embody all of the law in any single part of these instructions. In considering one portion, you must consider it in the light of and in harmony with all the instructions. The court has instructed you on all the law necessary for your deliberations. Whether certain instructions are applicable may depend upon the conclusions you reach on the facts by the greater weight of the evidence. If you have an impression that the court has indicated how any disputed fact should be decided, you must put aside such an impression because that decision must be made by you, based solely upon the facts presented to you in this courtroom. Circumstances in the case may arouse sympathy for one party or another. Sympathy is a common human emotion. The law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to weigh the evidence, to decide the disputed questions of fact, to apply the instructions of law to your findings, and to render your verdict accordingly. Your duty as jurors is to arrive at a fair and just verdict. Your initial conduct upon commencing deliberations is important. It is not wise to express immediately a determination or to insist upon a certain verdict. Having so expressed yourself, your sense of pride may be aroused, and you may hesitate to give up your position even if shown that it is not correct. Consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with the other jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender your considered opinions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. I will give you the exhibits and the verdict form. The foreperson will retain possession of these records, including the verdict form, and return them to the courtroom when you have reached a verdict. Until your verdict is announced in open court, you are not to disclose to anyone the status of your deliberations or the nature of your verdict. When you begin your deliberations, first select a foreperson. When 6 or more jurors agree upon the verdict, you will complete and sign the verdict form in ink and advise the bailiff. You then return to the courtroom, at which time your verdict will be announced. If you have a question, the question should be written down, given to the bailiff. The bailiff will deliver the question to the court, and I will respond. The question should not reflect the status of your deliberations. Deliberations may take place only when all jurors are in the jury room with no one else present. Should any juror leave the room, all deliberations must cease until all jurors are together. During your deliberations, no juror is permitted to disclose to anyone the status of your deliberations or the nature of your verdict. This order must be strictly obeyed. During recesses, you may not discuss the case with anyone, even other jurors. After your verdict is returned and announced in court, you may discuss this case with anyone, but are not required to do so. Counsel, desire anything further at this point?
No.
Kuzma?
No, Your Honor.
Nemrick?
Thank you.
No, Your Honor.
Any of the jury members have any questions? All right, so it's 1 o'clock. Figure out how you want to do lunch. Do you want to go, since it's after the lunch hour now, and eat something out? say, only a half hour or 45 minutes, or you can go out for 15, bring something back, and do a working lunch. That's up to you. I'll let you conduct that whatever way you want. There is no time limit on your deliberations. You take however long, however short it takes you in good conscience to do your duty. It is a single issue, so it's been my experience trying many jury trials that we will probably complete this today. However, we do have an artificial hard block today. I have a daughter getting married on Saturday, and I'm officiating, and the rehearsal is tonight. And she will disown me if I am not there on time. So I have to leave here at 4 o'clock sharp. So I would suggest that if you don't have it done by 4 o'clock, then you'll be coming back tomorrow morning at 8:30. Do you have a question?
I think most of us, and I could stand corrected, but would prefer to do a working lunch.
Yes.
Okay. So go ahead. You may deliberate, and then don't be long getting your food, and come back and get to work.
All rise for the jury.
Take your books. Your records reflect that the jurors have left the courtroom. Anything for the record before I switch gears to my next case?
No, thank you.
Okay. All right, so we're off the record.
Did they know what happened to the other juror?
We just assume he slept in.
I think they're assuming that he slept in, and he's AWOL. Tony, do they know what happened to number 8?
Do they know what happened?
Yeah.
No.
Okay.
Yeah.
We'll tell them
Never
after.
did the alternate.
Yeah, we'll tell them after.
They pretty much assumed when I brought him in the very first time, one of them said, so I guess he's the alternate. I didn't confirm.
So,
that worked out.
Pretty smart.
I happened to look up the last trial
And
we all had, and it was number 8.
Oh, was it?
Oh, was it?
That also was force selected as the alternate.
Yeah.
That was a whole thing.
So 8, when the 4 of us get together, 8's the unlucky number.
That's the one.
Oh, if you want to put your number that we can get.
Tony, I am
Oh.
printing 2
I
copies
was gonna say,
I know-
know you have.
I know
of the
you have.
instructions. I gave you the verdict form already. And the instructions are on the copy machine.
If I could have both your cell numbers.
Oh, yeah, we'll put it on close for you.
Don't go far. I've seen decisions, as I've mentioned, as short as 8 minutes and as long as 2 hours, so.
That 6-hour one I was telling you about, actually, Mr. Schlackett, if you remember, the county courthouse. I was sitting there, and I saw you, and he said, "What are you here for?" And I said, "Waiting for a jury to come back. It's been 5 hours." And he said, "For what?" I said, "Workers' comp." Very rare, so. Doesn't, I don't think that's going to be the case today, but you never know.
Jay, Downing What's, Downing said he's gonna be a few minutes late, why?
He had an appointment at 12:15, he said it was gonna take a little bit less than an hour or so.
All right, so he'll be here as soon as possible.
Thank you very much.
Thank you.
How you doing, Your Honor?
Good, how about you?
Good. How you gonna fix your daughter's wedding at election time?
Well, you know, it's
Bad timing.
It's bad timing.
Did you tell her you can't get
it's
married
bad
that
timing.
week?
I'm missing an important event on Saturday, but family comes first. What cameras? Why?
I don't know, and I can't get anybody because they asked me when they can reboot the servers. And then she left, and she's not answering because they need to reboot them so that they're accessible.
Which cameras are down?
Ours.
They're up now.
No, I have them. Matt can't get them, there's other people who can't get in. They didn't, he said they needed to reboot the servers, and she went to lunch. But mine are working too, but Shannon's aren't, Matt's aren't. So that means the YouTube is going out. So I'm trying to get it fixed before.
YouTube's working.
two more.
Sit down, there's two more.
All right, we'll get it in.
Size and use the second.
All right, second row. Yeah. Let's get it in. All right, let's get it in.
Brianna and Ayana. Brianna and Ayana.
Brianna
The
and
last, the second row right here, you guys.
Yeah,
Mary Jo and Dave here,
Oh,
teacher here, so go ahead.
yeah.
Go ahead. These two have to stay open. All right, very good. So you wait. You're not saying anything? Go ahead. Go ahead. Tony wants to fall back here. Is there any more to say over there? Yeah, you can. No, nice. I don't know, Tony, or I couldn't switch on here. They must stand, or they sit up here.
Yes.
You want to know if people ought to stand or if you should be, where should you be?
Sit, come on. It's called down.
Everybody's phones off? All right, thank you. She might, that's it.
Rise, Court of County, is now in session. The Honorable Eugene Lucci presiding.
Seated. We're on the record. This is case number 21 CR 001457, State of Ohio versus Julian K. Lawrence. Mr. Lawrence is present in court with counsel. Attorney Jay Schlackett, representing the State of Ohio, our assistant prosecuting attorneys Adam Downing and Rachel Wood. The defendant was here for a jury trial which started September 30th, 2022, concluded on October 13th of 2022. The jury found the defendant guilty in count 1 of aggravated murder, an unclassified felony with a 3-year firearm specification, count 2 of murder, an unclassified felony with a 3-year firearm specification, not guilty in count 3 of attempted murder, felony 1, guilty in count 4 of felonious assault, felony 2 with a 3-year firearm specification, guilty in count 5 kidnapping, felony 1 with a 3-year firearm specification, guilty in count 6 kidnapping, felony 1 with a 3-year firearm specification, and guilty in count 7, trafficking in marijuana, felony 5, with a 1-year and a 3-year firearm specification. I referred the defendant for pre-sentence investigation. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated October 20th, 2022. I have received 8 victim impact statements from various close relatives of the deceased, Ollie Gibson Jr. I've read these documents. It's my understanding that there is an error on page 16 and on page 22, but not on the face sheet, whereby one of the firearm specifications was left off of the finding of guilty on count 7. Should reflect that there was a 1-year and a 3-year firearm specification. As I stated at the beginning, I've met with counsel and probation in chambers, and I informed counsel that I am merging count 2 murder into count 1 aggravated murder. I am merging count 4 felonious assault, felony 2, into count 5 kidnapping, F1. I'm merging count 6 kidnapping, F1, into count 5, so that the sentencing would be on 3 counts: count 1 aggravated murder, count 5 kidnapping, and count 7 trafficking in marijuana, and 2 3-year firearm specifications, the one on count 1 and the one on count 5. Any objection to the merger?
There. No, thank you.
Mr. Schlackett, you agree that the jail credit is 357 days?
Do, Your Honor. Thank you.
Any reason not to proceed with sentencing?
No.
You may address the court first.
Your Honor, may it please the court. Thank you for all the courtesy you've shown us during the trial. Truly appreciate it. As you know, Mr. Lawrence is 26 years old. He's got absolutely no prior criminal history. I think he had a trespass or something like that when he was a juvenile. I'd submit to you, Your Honor, most respectfully, that the aggravated murder and the felonious assault and kidnapping, including the marijuana, which is obviously just an F5, that they should all merge because, Your Honor, the offenses were part of the same transaction and were a series of continuous acts bound together by time, space, and purpose and directed toward a single objective. I'm quoting that language, Your Honor, from a case called State versus Marshall, M-A-R-S-H-A-L-L. It's 2006, Ohio, 6271, where in that case, very simply, the defendant robbed a store, and there were a number of customers in the store, and he got all these specifications for all the different customers, and the court said that they should all merge because it was a continuous act bound together by time, space, and purpose, and directed towards a single objective. That sounds awful close to what we have here, Your Honor. In fact, I'd submit to you really exact. Unfortunately, we have to follow the Ohio Revised Code, and 2929.14 B1G requires that there be two gun specifications. I'd like to argue it was a continuing course and that there should only be one, but I think that'd be intellectually disingenuous, and I really can't argue that. So I think, Your Honor, most reluctantly, I have to concede that my reading of the law requires that there be 6 years in gun specifications. Those are obviously consecutive to and after or be prior to serving his indefinite sentence. Obviously, Your Honor, with respect to the aggravated murder, these are statutory sentences, so you're left with the option of 20, 25, 30, or life without parole. I'd ask you, Your Honor, to impose the 20 years, and then along with the 2-year or 3-year gun specs, so that would be life with parole eligibility after 6 years. I'd ask you to consider 2929.14C4, which notes that there's a presumption that there should be concurrent sentences unless consecutive sentences are necessary to protect society or to punish the offender, provided they are not disproportionate to the seriousness of the conduct and to the danger the offender poses to the public. He's 26 years old and having never been in trouble in his life. I'd also, Your Honor, ask that you consider the statutory requirements, such as whether the crimes were committed while another case was pending or while on supervision, which of course we don't have here. In order for the court to make a consecutive sentence finding the crimes, for crimes that were committed as a single course of conduct, the harm must be so great or unusual that a single term would not adequately reflect the seriousness of the conduct, or that defendant's criminal history shows consecutive terms are needed to protect the public. He has no prior criminal history, Your Honor, so that factor is out. With respect to the seriousness of the conduct, well, obviously it's serious. I mean, it's the most serious you can have. It was a homicide. There was no injury except to Mr. Gibson, of course, Your Honor. No one else was injured. This man has no criminal history. So I'd submit that under the factors of 2929.14, consecutive sentences would not be supported by the facts. With respect to that this is the worst form of the offense, Your Honor, all aggravated murders are the worst form of the offense. The worst form of the offense is where you have executions, or where you do things in front of children or things like that, or you have multiple victims. This is certainly by any stretch not the worst form of the offense. I mean, it's obviously it's an aggravated murder, so in and of itself, intrinsically, it's a terrible offense, but it's not the worst form of the offense. So I would ask you, Your Honor, to impose the life with parole eligibility after 20, plus the 6 years mandatory prior to and consecutive, for a total sentence of 26 years. Thank you.
Julian Lawrence, the law allows you to say whatever it is you want me to consider before I sentence you. Do you have anything to say?
No, Your Honor, I hope that you will not take his lack of allocution and hold that against him. Obviously, he intends to appeal this, and it's under advice of counsel. He's been instructed that anything he could say could potentially be used against him, and I've cautioned him and the counsel will not do that. Thank you.
All right. Let me hear from the state.
Thank you, Your Honor.
I want to address a couple things before I get into our state sentencing recommendation. First of all, we'd ask that for forfeiture of the defendant's firearm, ammunition, and magazine in this case. And there was also a number of items in the victim's vehicle that his family and one of the individuals in the car have expressed interest in retrieving some personal items. So far, I've instructed them to wait until the trial is done, and understanding that this case may be or is going to be appealed in the future. We want to preserve that vehicle. However, all of the items that the family have expressed that they want back are inside the trunk of the car, which was not at issue at all in this case. None of that evidence was presented, and that evidence, that area was combed through by both the Painesville Police and the Cuyahoga County Medical Examiner's Office. So I just want to put on the record that our intent after sentencing is to have the Painesville Police Department remove those items out of the trunk, document them, photograph them, and then release any items as necessary to the family or any parties that can claim ownership of those, and then create a supplement so we can document that for the future and then place those items back into the trunk, any items that were not claimed.
Mr. Schlackett, on that issue, any objection?
No, Your Honor.
All right, continue.
As for the merger in this case, I disagree with Mr. Schlackett. I do agree that if the court imposes a consecutive prison term, it would have to be because two or more of the multiple offenses committed as a single course of conduct, and the harm was so great or unusual that a single term does not adequately reflect the seriousness of the conduct. I agree with Mr. Schlackett in that. However, I disagree with him that consecutive sentences should not be imposed. I do believe they should be imposed, and here's why. We have, in this situation, a course of conduct that really is three separate acts. We have a trafficking in marijuana, which in and of itself was its own act. Then we have an aggravated murder, which was its own act. And then we have a kidnapping, which was its own act. And through the testimony that was presented at trial, those three separate crimes can be divided up as three separate instances, but as one single course of conduct. Although no other persons in this case sustained any other physical injury other than the victim, Ollie Gibson, I do believe that there is something to be said about the fact that there are other individuals in the car. They watched their friend die in front of them. And for Jeffrey Isaacs, who was a separate victim in this case, he had a gun pointed at his head and was forced to do things and had his liberty restrained. And I do think that is a separate and identifiable harm that should be accounted for. So I would ask that those counts are run consecutive to each other, the aggravated murder in count 1, the kidnapping in count 5, and the trafficking in count 7. As for some of the factors in this case that I think are important to consider, the offender's relationship with the victim did facilitate this offense. They knew each other beforehand. That's how this meeting came to be. The people in the car for purposes of aggravated murder, like I said, did watch their friend die in front of them, and this will affect them for the rest of their life profoundly. I think that is something to consider. I do not believe that the defendant in this case has shown any genuine remorse, and although I do understand that he intends to appeal this case and disagrees with the jury's outcome, what is clear through the pre-sentence report is that he doesn't show remorse for what happened. He blames others for their potential crimes. He notes that the other people involved in this case, he says, quote, they are criminals, which is exactly in line with what the state presented at trial, in part that the defendant thought that his CCW license allowed him some greater legal authority over others when it came to acting in self-defense, and it simply does not. That became clear, I think, through trial. It becomes more clear through the pre-sentence report. It was clear from his testimony. He obtained this weapon and got a CCW permit that arguably he wasn't supposed to have in the first place based upon some of the testimony that he had in trial. And he used that weapon to then engage in illegal activity, namely trafficking marijuana. And one of the things that stood out to me that was surprising was that in the pre-sentence report, the defendant stated that he stopped consuming marijuana when he was 22. Well, that's simply not true. It's not even consistent with what he testified to. So there is a drug and alcohol problem there that appears to be related to this. In this case in particular, he brought 36 rounds with him to a meeting. That is obviously not self-defense. The manner of this murder, although Mr. Schlackett, I think, correctly notes that in a case like this, when you're dealing with aggravated murder, they're all terrible and serious offenses, but I do believe there are factors for this particular case that make this more serious. In this case, the defendant put himself in this situation. What was clear from the jury's verdict and clear at trial, I believe, was that the defendant was the aggressor in this case. He shot the victim 14 times, which was excessive. He walked alongside the car for 68 feet, which was excessive. And then when the police arrived on scene, he was not truthful with them. He continued to perpetuate falsehoods to law enforcement authorities to prevent himself from being brought to justice, because he believed that his concealed carry permit was going to let him out of jail. And I think what's clear from the trial is that that is not the case. So I do believe this is a more serious offense, and that needs to be reflected in the sentence given to the defendant. The state is asking in this case on count 1, the aggravated murder, for a term of 30 years to life. On the kidnapping, a term of 8 years, which is a Reagan-Coates Senate Bill 201 offense, so that would be 8 to 12, and then 12 months on the trafficking to be run consecutive to each other for a total term of 45 to 49 to life when you include the 6 years of specifications. I think that's an appropriate sentence in this case, and I'd ask the court to impose that appropriate sentence. Thank you.
Do you have any witnesses to present?
No.
Mr. Schlackett, anything further? I've considered the record, the oral statements made, the trial, the victim impact statements, pre-sentence report, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden on governmental resources. I've considered the separate recommendations of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing, and be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victims, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code Section 29.12. In that regard, there are factors that make the offenses more serious. In the first place, the court does perceive 3 separate and distinctive acts of crime committed. The court thinks that they are entirely separable, those being the 3 acts on which I am sentencing the defendant: the trafficking, the aggravated murder, and the kidnapping. Certainly, based upon the evidence in the case, and unlike most pre-sentence reports, I'm not reading the police report. I actually heard the witnesses testify in a fairly lengthy trial. The defendant was the aggressor. The evidence was he did walk along the car for a total of 68 feet from the point where he dropped his cell phone to the point where the last casing landed on the pavement. He fired 14 shots. The evidence was that this was in retaliation for a perceptive wrongdoing on the part of the deceased, and actually the court does consider it to be an execution. There were a large number of victims, 2 victim bystanders who watched bullets fly in front of them into the body of Ollie Gibson. Front seat passenger, those bullets had to have been inches from him. With the large number of shots, it indicates a purposeful taking aim. I believe every one of those shots hit the deceased. The bystanders suffered serious psychological harm by witnessing this, psychological harm by watching their close friend being killed. There's a large number of family victims. I mentioned I have 8 victim impact statements. The family, the siblings, the parent. All of these people have been devastated by the death of their loved one, and certainly the offender's relationship with the victim facilitated the offense. All of these factors make the offenses more serious. There are no factors making the offenses less serious. In terms of recidivism, the court finds that the defendant is not remorseful. He offered many excuses to the probation officer conducting the interview. The excuses were along the lines of his testimony in denial of the charges, and in fact, the court views the evidence that the defendant thought that a concealed handgun license gave him a license to kill. In terms of making recidivism unlikely, the defendant has a negligible record and has been law-abiding for a significant number of years. However, I temper that statement with the image of the defendant that was taken from either his phone or somebody's phone, with him standing with a large amount of marijuana. Looked like an F1 level worth of marijuana. The defendant claims it wasn't his. It doesn't matter. He was in possession of it long enough to have dispossessed it. He did show up at a drug deal with a firearm. So giving him credit that was the very first time that he showed up to do a drug deal, when I say he's been law-abiding for a significant number of years. But the evidence was that he was a man you can go to buy drugs, particularly the marijuana. Prison is mandatory on the 2 firearm specifications attached to counts 1 and 5. Count 5 is a Senate Bill 201, qualifying offense for an indefinite sentence, so the court has to pick a minimum term on the F1 kidnapping from between 3 and 11 years. Half of that will be the indefinite tail. The penalty for aggravated murder is life with 4 options: 20 years minimum, 25 years minimum, 30 years minimum, no parole minimum. The court determines that consecutive sentences are necessary to protect the public and punish the offender, would not be disproportionate to his conduct and the danger he poses, and that the harm is so great or unusual that a single term would not adequately reflect the seriousness of his conduct. Court determines that the offender committed a worst form of aggravated murder, and I, having seen the evidence, characterize it as an execution in retaliation. In fact, the evidence could easily lead one to believe that even the trafficking was a ruse to get the defendant, or the decedent, in close proximity with the defendant for the purpose of the execution. Accordingly, it is the sentence of this court that you serve a period of incarceration in state prison for 3 years on each of the 2 firearm specifications on counts 1 and 5, for consecutive with each other for a total of 6 years, serve consecutive with and prior to the sentence on counts 1, 5, and 7. On count 1, the court is imposing life with first parole eligibility after 30 years. On count 5, an indefinite term with a minimum of 8 years and a maximum, Senate Bill 201, of 12 years. On count 7, 12 months. Counts 1 and 5 are consecutive. Count 7 is concurrent for a stated aggregate minimum of 38 years and an aggregate maximum of 42 years. That's after the specifications of 6 years. So with the specifications, the sentence is life with first parole eligibility after 44 years to 48 years. The credit is 350 days. You're to forfeit all instrumentalities, pay the costs of confinement, prosecution, supervision, treatment, and court costs. Of course, on the life, parole is up to the parole board, but on the F1, you could be on post-release control, must be on post-release control for a minimum of 2 years up to a maximum of 5 years, where they can return you to prison on that count for up to 9 months for any one violation and up to 1/2 the original minimum term, 8 years. So 4 years for all violations in the aggregate. All of that time is part of the sentence. Should the violation be a new felony, the judge in a new felony case, in addition to sending you to prison on a new case, can send you back to prison on that count for the greater of 1 year or whatever length of time up to 5 years that is remaining for all for the violation. Under the law, there are some credits, the 8%, 10%, and the 5 to 15% credits. I'm mentioning them, but I don't think they're applicable. You're not allowed to earn credit on a violent offense or mandatory prison, and the specs are mandatory prison. The life is a mandatory prison, and certainly the kidnapping is a violent offense. So I don't think they're eligible, but you can inquire about that. So long as you owe any court costs, the state can block your motor vehicle license plates until the court costs are paid in full. By virtue of the conviction of the aggravated murder and the kidnapping, you are a violent offender and must be entered into the violent offender database. You're required to provide the sheriff certain information, including full name and alias, residence address, social security number, driver's license number, information regarding the offense, name and address of any place of employment, name and address of any school, license plate number, and VIN number of any vehicle used by you, description of scars, marks, and tattoos. You're required to provide the sheriff fingerprints, palm prints, and photographs after the date of the initial enrollment, and you would do this within 10 days of release from confinement. You're required to re-enroll annually. If you change any addresses, you're to provide written notice of those changes. You're required to do this for a period of 10 years. In Lake County, the registration office is currently located at 84 North State Street in Painesville. That could change, likely to change. I'm giving you the notice of duties to enroll, and you'll sign the receipt at line 10. Counsel, if you would approach.
Executed the form in open court. signature thereon.
Thank you. I will also sign the document, make it part of the record. You're now under a firearm disability. Cannot purchase, own, possess, or use firearms or ammunition for firearms. There are other disqualifications. You cannot vote from prison. In order to regain your ability to vote, you would have to re-register upon your release from prison. You cannot serve as a juror. You cannot hold any position of public honor or trust. Bond, if any, is released. You have a right to appeal any of the many decisions I've made throughout the case. Appeal the jury's verdict by filing a notice of appeal in this court within 30 days of the date on which I journalize this entry. The entry will be journalized probably by tomorrow, just to give you an idea when the period would run. The court denies an appeals bond, and I will appoint private counsel for the appeal. I'm assuming that you want me to appoint separate counsel, correct?
I certainly do, Your Honor. Thank you for that. Can I just make a couple comments around
Yes.
the record? Number one, we obviously object to the imposition of rating totes. We believe it is an unconstitutional statute. It's pending, of course, for all the courts in Ohio. The Supreme Court itself is going to soon rule on it. The Mazda, you may remember that Mr. Lawrence was driving, Your Honor. That was not titled to him. It's his mom's car. She desperately needs it so she can work. The car's been impounded. I'd ask you to issue an order releasing that vehicle to her without cost. And other than that, I don't have anything else. Thank you.
Mr. Downing, as to the Mazda, it had a hole in it from a bullet.
That's okay.
All right. So the Painesville Police will facilitate through the prosecutor's office the release of the Mazda SUV to Mr. Lawrence's mother. That's who it's titled to?
Yes, and we're going to keep any evidence that was collected under it, including the taillight, but the vehicle itself.
Without objection, Your Honor. Thank you for
All right. And certainly, as with the other items that are in the trunk of Mr. Gibson's car, document it all, and it's all by agreement. And does the state have anything they want on the record as far as the Reagan-Tokes objection? Obviously, the Supreme Court will rule on that, whether it's constitutional or not.
I have nothing additional to add.
And if the court ruled it unconstitutional, there's nothing in my sentence that isn't easily severable, right? It would just be the tail of 4 years that would be taken off. All right, nothing further?
Earlier you said 357 days credit, and you said 358. I just want to make sure it's right.
Well, in Chambers, we said 356, and I added one and made it 357 because he was actually detained right from the scene.
Right. And then I think, but then later on the record, I believe you said 358. It doesn't matter to me. I just want to know.
Okay. If I said 358 or if I said 356, they're both wrong. It's 357.
Thank you.
And that's what I have on my notes. And Mr. Schlackett, anything further?
No, thank you, Your Honor.
All right, we're adjourned.
Hazel, please. We'll let him know. It's, where is it right now? All right, so we'll have to, well, you don't have to tow it back. Yeah. He's out this week, so.
Did a garage improvements thing.
Mm-hmm.
And so there wasn't a conviction, he was going to give us the guy the privileges. And he had a diversion, and he hasn't moved it. He admits, you guys admitted that there was no conviction. Doesn't he rule on that? It's been 5 months.
Yeah, that, sometimes that happens.
Yeah. Good to see you.
No, he can apply for parole
At 44.
at 44.
44.
Yes.
Yeah.
Yeah, definitely a senior citizen by that point.
And they want us to go to the first one.
Oh, okay. Whose is this? Oh, I thought
That's for the trial.
Wait, what do you want me to do? Oh.
A picture?
It's something we're gonna start on a big case. It's like 7 or 8 pictures of all across the
Yeah, could have just said they were sentencing, you're not going to worry about it for a while.
All right. All right.
May be seated. You're back on the record. The jurors are in the courtroom. And has the jury reached a verdict?
We have, Your Honor.
And foreperson is Jeffrey Sandor.
Correct.
Hand it to the bailiff, please. We, the jury, find that Timothy J. Murphy is entitled to participate in the Workers' Compensation Fund for the condition bilateral carpal tunnel syndrome as having occurred while in the course and arising out of his employment with the City of Painesville, at least 6 of us so agreeing, as indicated by our signatures below. And there are 6 signatures, and I will ask number 3, Todd Sumner. This is not your verdict, correct?
Correct.
And number 9, Robert Rux. This is not your verdict.
Correct.
All right. The rest of you, this is your verdict?
Yes.
Okay. Anything else with the jury?
No, I just thank you again. If anyone had a few minutes after to talk, I would